Students are joining. We'll start in a minute. Hello, good morning, and welcome to Byju's Exam Prep. Yesterday, we initiated a discussion on right to equality, where we discussed Articles 14, 15, and 16. We looked at what is the difference between equality before law and equal protection of the laws, and what are the exceptions under Article 14. Then we looked at Article 15 and 16 and how the state cannot discriminate against citizens on various grounds. But these two articles are also not absolute fundamental rights because there are some exceptions. For example, for socially and educationally backward classes of citizens, which includes SCs, STs, OBCs, and for the economically weaker sections of the society, there is a reservation in educational institutions as well as in government jobs. But at the same time, Article 15 and 16, although they talk about non-discrimination, but there are exceptions, and these exceptions have been upheld by the courts as well. Now we will look at Articles 17 and 18 and be done with right to equality, and then we will start right to freedom, where we will discuss Articles 19, 20, 21, and 22. Article 17 talks about abolition of untouchability. And if you look at the text of Article 17, it says untouchability is abolished and its practice in all its forms is forbidden. But when we look at this Article 17, untouchability as a term is not defined in the Constitution. And if you look at it closely, this term untouchability is in quotes. That means we are not referring to the literal meaning of this term untouchability. We are referring to something else. And what are we referring to? We are referring to the historic practice of discrimination. What does that mean? Let me make it simple. COVID-19 pandemic struck the world, struck India as well. And then what we saw that those who were suffering from COVID-19, they were quarantined. That means they were excluded. They were not allowed to come out. They were kept under isolation initially for 14 days, then for 7 days. Now there is no isolation at all. The point is this untouchability? In a sense, we are discriminating against one section of the society and we are not allowing them to mingle with others. Is this untouchability, and this form of untouchability has been prohibited under Article 17? No. There is somebody who is suffering from leprosy, and we see that there are various states where there are separate colonies for those who are suffering from leprosy. They are excluded from the other sections of the society. Is this form of untouchability which is abolished and its practice is forbidden under Article 17? No. When Article 17 says untouchability is abolished, we are not referring to the literal meaning of this untouchability. Don't touch me not. No. We are referring to the historic practice of untouchability, historic practice of discrimination on the grounds of caste. Clear? So we have looked at various examples how after the later Vedic period, initially what was supposed to be a Varna system, where there was some sort of division of labor, where those who would provide education, who would give knowledge, they would be referred to as Brahmins. Those who would participate in wars and be responsible for upholding the territorial integrity of a country, those individuals would be called Kshatriyas. Those who are responsible for trade activities, commerce, they would be called Vaishyas. And those who will serve the other three groups, they would be called Shudras. But what was initially a sort of division of labor, that became something exploitative, discriminatory, and that became on the basis of birth. So initially, this gradation in the society was based on division of labor, was based on how we can allocate roles and responsibilities to different groups. But then it became by birth. That means those who are born to Brahmins will be Brahmins. Those who are born to Shudras will be Shudras. So what was initially a division of labor became an exploitative practice after the later Vedic period. That is why we see when Swami Dayanand Saraswati, he gave a slogan, back to the Vedas. He was referring to the early Vedic period, where in early Vedic period, there was no discrimination on the grounds of caste. It was not basically a caste system, it was a Varna system based on division of labor. But then it became exploitative, where some members of the society, they were not allowed to drink water from a well which was reserved for the upper caste, where they were not allowed to eat food in presence of the members of the upper castes or the so-called upper caste. Intercaste marriage is a distant dream. They were not even allowed to talk to those who belong to the upper caste. So that form of discrimination, that historic practice of untouchability, that has been forbidden and abolished by the Constitution. And we say this is an absolute fundamental right. Without any ifs and buts, without any exceptions, untouchability is abolished and its practice in all its forms is forbidden. No matter who practices untouchability, action will be taken against them. That means here we see no exceptions whatsoever. But to implement this fundamental right, Constitution says untouchability is abolished and its practice in all its forms is forbidden. And I will explain what do we mean by practice in any form. But Constitution does not talk about punishment. Constitution does not explain what is untouchability. Constitution does not talk about what will happen to those who indulge in untouchability. For that we needed a law. And that law initially was called Protection of Civil Rights Act 1955. But then even after this law was passed, we still saw the practice of untouchability. So this law was considered to be a weak law against the horrible practice of untouchability. So we needed a stricter law. And that stricter law was passed in the year 1989. And that law is what is known as the Atrocities Act. In common language, we call it Atrocities Act, but the proper formal name of this law is Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. This act was passed in 1989 and significant amendments to this law were made in 2015. And even stricter law was made in the year 2018. So what are we talking about? Article 17 of the Constitution, which is an absolute fundamental right. There are no exceptions whatsoever. For example, when we look at Article 15 or 16, we say the state shall not discriminate only on the grounds of religion, race, caste, sex, place of birth, descent, residence, but there are exceptions. For socially and educationally backward classes of citizens, there are exceptions. For economically weaker sections of the society, there are exceptions. For women and children, there are exceptions. But there are no exceptions under Article 17. Article 17 in our fight against untouchability is an absolute fundamental right. But this term untouchability has not been defined in the Constitution. But Constitution specifically, deliberately has mentioned this term in quotes, which means we are not referring to the English meaning of this term untouchability or literal meaning of this word untouchability, touch me not. We are referring to the historic practice of untouchability, where the members of the Dalit community, where the members of the tribal community, they were discriminated against and they were exploited by the other sections of the society. But since Constitution does not explain what is untouchability, does not define it, and does not prescribe punishment for those who will still indulge in untouchability, that is why the need for a law was felt. And that is how Protection of Civil Rights Act was passed in 1955, but it was considered to be a weak law, which was not helping in our fight against untouchability. That is why the need was felt to have a stricter law. And that strict law was passed in the year 1989, which is popularly known as the Atrocities Act. And to this Atrocities Act, significant amendments were made in 2015. Another significant amendment was made in 2018. Let's discuss what this act is all about and how can we help, how can this law help in our fight against untouchability. What can we say when untouchability is practiced? What sort of practice is forbidden under the law? When we say untouchability is abolished and its practice in any form is forbidden, what are these various forms of untouchability that we see in our society which has been prohibited by the law? For example, refusing admission to any person to public institutions, such as we have hospitals, educational institutions, but we discriminate against the Dalits and the tribals and say you are not allowed admission in a hospital or an educational institution. This is one form of untouchability which is forbidden by the Constitution. Similarly, preventing any person from worshipping or offering prayers in any place of public worship. We saw the instance in the later Vedic period and onwards, during the colonial period as well. If I am a member of the Dalit community, I can contribute. Look at the height of discrimination. I can contribute, I can give money for the construction of a temple, but I'm still not allowed entry inside the temple to pay obeisance at the deity. So this is the form of untouchability, and this has been prohibited and forbidden by the Constitution. Similarly, in the year 2015, when significant amendments were made to this law, the ultimate picture today becomes, no matter what you do, whether you insult a member of SC or ST community, whether you preach untouchability, whether you justify untouchability, that is a crime. How? If you are calling somebody as untouchable, saying that this individual has to be barred from entering inside the temple or an educational institution, you insult them saying your whole existence is a lie. You insult them saying they belong to the cheap sections of the society. You insult them that basically you come from a society which is polluting. You are insulting somebody based on his Dalit identity, his tribal identity. This is a crime. Now, you may not be physically or you may not be personally insulting them, but you may be preaching it. Preaching in the sense, you would tell the members of your community that we should boycott the members of tribal and Dalit community. Let's impose boycott. If I have a shop, I will not give groceries to a member of Dalit or tribal community. If I have an educational institution, I will refuse admission to them. This is the form of untouchability where you are preaching it, where you are preaching other sections of the society. You have to boycott these individuals because they are impure, they are polluting, and they are responsible for the problems of our society. This is a crime. You may not be insulting, you may not be preaching, but you may be justifying. You may be wrongly quoting the text. For example, the Hindu religious text. You may be wrongly quoting the Ramayana or Mahabharata or Gita or other religious texts, saying our laws in our religion, they have justified untouchability. So you are justifying untouchability. This justification of untouchability is also a crime. And this is where we come across something very, very important. And what is that important thing? Presumption of guilt. What is this presumption of guilt? For example, after the end of the class, I was walking on the stairs and suddenly there is another colleague. I accidentally push this colleague and the colleague falls down the stairs and ultimately dies. Unfortunately, will I be arrested for murder? Will I be convicted for murder? For that, we need to understand mens rea. What is mens rea? Intention. Was my intention to kill this individual? No. That means we were working together, but unintentionally, I pushed this gentleman, because of which he fell down the floor and ultimately was killed. But my intention was not to kill this individual. That means mens rea talks about intention to commit a crime. When you intentionally push somebody down the stairs and he dies, then you will be convicted for murder. I will not be convicted for murder because this was an unintentional murder. I may be convicted for homicide, unintentional murder, but I will not be convicted for murder. And when this matter will reach the court, police has to independently verify whether I have committed this crime or not. Police has to prove, executive has to prove that it was my intention to commit this crime. That means the courts will assume that I'm innocent. The courts will assume that I'm innocent. It is for the police to prove that no, I'm guilty. And that is how the court will decide whether I'm guilty or innocent. But in case when it comes to untouchability, presumption of guilt is always with the accused. If there is an individual and the other individual, you belong to a non-Dalit community, but you are in a tussle, in a conflict with a member of the Dalit community. So this member is approaching the police saying this gentleman has insulted me because of my caste, preached and justified untouchability. The courts will assume that you are guilty. Now you have to convince the court that you are not guilty. So presumption of guilt will always be there with the accused. The court will presume that you are guilty. In other cases, in normally other cases, the courts will assume that you are innocent. It is for the police to prove you are guilty. In this untouchability offenses case, the courts will assume that you are already guilty. Now you convince us why you are not guilty. And maximum punishment that can be awarded under the Atrocities Act is the punishment of death. So what are we talking about? Article 17 says untouchability is abolished and its practice in any form is forbidden. But this term untouchability has not been defined in the Constitution, and no punishment has been prescribed in the Constitution for those who will still indulge in untouchability. That is why for that we have a law which is popularly known as the Atrocities Act. And under the Atrocities Act, we have various examples given that these are what we call the practice of untouchability. And if you do that, you will be convicted under the Atrocities Act, for which the maximum punishment can be death as well. And what are these examples of untouchability? If you refuse admission to a Dalit or a tribal member in educational institution or in hospitals, if you refuse or you stop somebody who is from Dalit or tribal community from entering a place of worship and worshipping their God, this is untouchability, and this has been abolished. In any form, it is forbidden. So if you insult somebody, if you justify untouchability, if you preach untouchability, it is all crime. And when there is an allegation against you that you have insulted me because of my Dalit identity or my tribal identity, or you have preached or justified untouchability, here the courts will assume that you are indeed guilty. Normally the courts assume that you are innocent. That's the golden rule of criminal justice system. You are innocent until proven otherwise. You are innocent until proven guilty. But in untouchability case, since this is a historic, horrible, preposterous practice of untouchability, the courts will assume that you are guilty. Now you have to convince the court whether you are innocent or not, how you are innocent. And that is how we say this is a stricter law which helps us in our fight against untouchability. But in the year 2015, more examples were added. More forms of untouchability were added, so that if you indulge in these practices, this is also untouchability. For example, still in some villages in India today, if you are a member of the Dalit community, you cannot ride a horse. So if you're riding a horse, and on this horse, for example, it's your marriage ceremony, you're riding a horse, you want to go to the bride's home and you want to get married to the bride. If you are riding a horse, it is not allowed by the members of the so-called upper caste. If you insult somebody and if you stop somebody who is from the Dalit community from riding a horse, this is untouchability and you will be arrested. Similarly, in ancient India, and unfortunately today as well, somebody sporting a mustache. Sporting a mustache was considered to be the privilege of the so-called upper castes. And if a member of the Dalit community was sporting a mustache, he was shaved off this mustache. Now this is a crime. If you see a member of the Dalit community sporting a mustache and you want to shave it off, this is a crime. You are guilty of untouchability. Similarly, some members of the so-called upper castes would garland the members of the Dalit community with shoes, with chappals, with slippers. This was one form of untouchability. This is now prohibited under the 2015 amendments. And these more and more examples, more and more forms have been mentioned under the amendment to 2015. And these amendments have made it a stricter law in our fight against untouchability. But then something else has happened. What has happened? Matter went to the court. Subhash Mahajan case, August 2018. It was argued that this practice of, or this law, Atrocities Act, has been used, overused, abused, and misused. Misused in the sense that here is an individual A, here is an individual B. This member A belongs to the Dalit community. This member belongs to the upper caste, for example. Now, this gentleman A was in need of money for some purposes, for marriage, for education, for trade, whatever. And now this person has lent money. Now this person B is asking this money back from person A. Person A is refusing. When person A is refusing, A and B enter into a brawl, into an agreement, into a fight. And what this A is doing, he is approaching the police and an FIR is filed. FIR is filed under which law? Under the Atrocities Act. And the moment FIR is filed, this person A is arrested. The moment this complaint is filed, because this is a stricter law, as I was talking about, a stricter law, the moment this complaint is filed, the police arrests this member of the upper caste. And then there is no bail. Bail becomes almost impossible in this case. There is no bail. And over a period of time, we know that wheels of justice, they are very slow in India. The case drags on for many years. And after many years, the court rules, the court decides, yes, you are not guilty, you are innocent, you are set free, because this was not the case of untouchability. This was the case where you had lent money to person A, you were only asking for your money back. So this law has been used, overused, abused, and misused. Matter went to the Supreme Court and Supreme Court said, we will have to tweak this law. What is the tweak? The Supreme Court said, there will be no automatic registration of FIR and arrest. So if person A is approaching the police filing an FIR, wants to file an FIR, the police will not immediately file an FIR, the police will not immediately arrest that individual. The police will have to convince itself that this was indeed the case of untouchability. That means what the police has to do, it has to conduct a compulsory preliminary examination, which means the police party will meet various people, will ask various people what is exact dispute between these two individuals. Is this a case of untouchability? Then they will realize, no, this is not the case of untouchability. This was basically a money affair where money was lent to this person. Now all this person wanted his money back, but this person refused. And ultimately he filed a false case under the Atrocities Act. That means no immediate registration of FIR, no immediate arrest. There has to be a compulsory preliminary inquiry. And if this inquiry says that there was no such case as untouchability, no FIR will be filed. That means no arrest will take place. And if there is an element of untouchability found out in this preliminary inquiry, then the police will have to take permission from their seniors, who can be a deputy SP, who can be a superintendent of police. Only after their written permission can these individuals be arrested under the Atrocities Act. Because the Supreme Court said in 2018, August, that Atrocities Act has been used, overused, abused, and misused. And we can realize by looking at the conviction rate. Conviction rate is very low. What is conviction rate? If 1,000 people are arrested under the Atrocities Act, because there is immediate FIR, there is immediate arrest. If 1,000 people have been arrested under the Atrocities Act, over a period of time when the case reaches the court acquits, sets free majority of these accused. Basically saying that since conviction rate is low, ultimately it means that this law has been used, misused, abused. After this judgment was given, there was a lot of hue and cry in the society. There were protests in different parts of the country by the activists, by the members of the Dalit community, arguing that you have weakened this law. Despite this law, we are facing discrimination. Now, if you have reduced the significance of this law, there will be more and more atrocities against us. Which means even today, the police is refusing to file the FIR. Now, if you are saying that there is no automatic registration of the FIR, there needs to be a written permission by the DSP or a superintendent of police. You are complicating the entire process. So we will see the incidence of untouchability will increase in the society. Ultimately, Parliament got together. Parliament amended this law in 2018. What is this amendment? Basically, status quo ante was restored. What is status quo ante? When amendment was made to the Atrocities Act, Parliament basically overruled the Supreme Court verdict. When Parliament overruled the Supreme Court verdict, basically restoring the same position as was in existence before this verdict in August 2014. What does that mean? This is, for example, July 2018. Under the Atrocities Act, when a complaint is filed, automatically FIR has to be registered. Immediately, you have to arrest that individual. No bail whatsoever. That means this is a case of untouchability. But in August 2018, Supreme Court said, no, there has to be no automatic arrest, no immediate registration of FIR. There has to be a compulsory preliminary inquiry. And if this inquiry makes out a case of untouchability, then for arrest, you have to take permission from the seniors. After this verdict, government asked the Parliament, let's change the law and let's restore those positions back in this law. What are these restorations? That is what we call status quo ante. That means what was the status of this law before this judgment? That status was restored. Which means even today, if there is a case under the Atrocities Act, immediate arrest will take place. Automatic registration of FIR will take place. There is no need for a compulsory preliminary inquiry. There is no need for a written permission by the DSP or the superintendent of the police, which means whatever the status of this law was before 2018 August, that status has been restored. Which means the Supreme Court, which tried to dilute the efficacy of this law, the efficiency of this law, that dilution has been done away by the Parliament. Parliament has restored the original law. Matter went to the court as well. Matter went to the court. My God, my Lord, what has happened? What has happened? Sir, Parliament has repealed, basically diluted your judgment. You said that there is no immediate FIR. There should be no automatic arrest. There has to be a compulsory preliminary inquiry. There has to be a written permission by the DSP or the superintendent of police. Now Parliament is saying all this is useless, will not be implied. Supreme Court, a 3-judge bench of the Supreme Court in October 2019 upheld these amendments and basically set aside this Subhash Mahajan case. That is Article 17 of the Constitution. So what is Article 17? Untouchability is abolished and its practice in any form is forbidden. But what is untouchability? We don't know because Constitution does not define it. And what are these other forms of untouchability? We don't know because Constitution has not defined it. What will happen to those who will still practice untouchability? We don't know because Constitution has not prescribed any punishment. And for that, a law was passed in the Parliament, a stricter law in 1989, popularly known as the Atrocities Act. So if you indulge in untouchability, whether you insult somebody, whether you preach untouchability, whether you justify untouchability, whether you garland a member of the Dalit community with shoes, whether you shave off their mustache, whether you stop somebody from riding a horse, all these are the practices of untouchability, forms of untouchability which have been abolished. And if you indulge in them, then you can be booked under the Atrocities Act. And there the courts will assume that you are guilty. You have to convince the court that you are not guilty. That means here the courts will have the presumption of guilt. Presumption of guilt is with the accused. You are presumed to be guilty. Now it is for you to convince the court that you are not guilty, you are innocent. There will be automatic arrest, immediate registration of FIR, and then ultimately, since the case drags on for a long time, the courts will assume you are guilty. And the maximum punishment that can be given under this law is the punishment of death. That's Article 17 of the Constitution, which is an absolute fundamental right. Any questions as of now? Let me know, then we will jump to another. Okay. Let's look at the last article under this category, right to equality, Article 18, which talks about abolition of titles. What is a title? Title is something which hangs to your name like an appendage. For example, the year was 1885. Which political party was formed in 1885? Indian National Congress. The same year, there was another organization formed, which can be very important for your prelims examination when it comes to modern history. The name was UPA. Not the Congress's UPA, United Patriotic Association. This United Patriotic Association was formed by Syed Ahmad Khan and Raja Shiv Prasad of Banaras. So they started this United Patriotic Association, which means they are patriotic towards the British. And ultimately what happened? Syed Ahmad Khan was given a title. You are now Sir Syed Ahmad Khan. Although Sayyid Ahmad Khan was a literate, he was a scholar, he helped in the establishment of Anglo-Oriental College in Aligarh, which later on became Aligarh Muslim University. But there were others who were given this status of titles were given. For example, Sir, for example, Rai Bahadur, for example, Maharaja. These titles were given not because of their contribution, not because of their talent, not because of their expertise, not because of their knowledge, only because they were loyal to the British Empire. For example, there was one gentleman, Raja Digvijay Singh. Raja Digvijay Singh, he was illiterate. Now, it's not a crime to be illiterate, but he was given the status of Raja, Maharaja. He was given a title by the British. And then he was nominated to the Legislative Council as well. Legislative Council, where initially Indians were nominated, but those Indians who were patriotic to British Empire. He was asked, how do you decide, because you're not literate, how do you decide whether you have to support a particular bill in the Legislative Council or you have to oppose it? How do you get to know what are these gentlemen discussing in English language? He said, I don't know. I look at the Viceroy. Whenever Viceroy raises his hand, I also raise my hand. When he does not raise his hand, I also keep my hands lower. So British created a society where there were two classes, upper class, lower class. And within this class as well, they would patronize some people by giving them titles, which created a divide in the society, which violates equality as well. Some are called Sir, Rai Bahadur, Maharaja, and some are not given these titles, which basically means you are violating the principle of equality. And this was the practice where, if you look at the revolt of 1857, when a massive revolt broke out in the northern and central part of India, which nearly swept away the British rule. For more than 2 years, artisans, handicraft people, villagers, farmers, they fought heroically and almost swept away the British rule. After the revolt of 1857 was defeated, then there was an analysis conducted by the British. How did we save ourselves so that we can help in our continued control over India? One official, William Edwards, he wrote that if it was not for the princes in the princely states, if it was not for the educated class, if it was not for the capitalist class, if it was not for those where we have calculated and cultivated loyalty, we would have been swept away from India. It's because these princes in the princely states saved us. The capitalist class supported us. The educated class supported us. These individuals whose loyalty we have cultivated because we have given them titles. It is because of them that we were able to crush the revolt of 1857. But after the Constitution was enacted, when the Constituent Assembly was debating a right to equality, they said, now these titles should be abolished. We don't want some sort of gradation in the society where some would be called Sir, some would be called Maharaja, some would be called Rai Bahadur. No titles can be awarded. So that is how all the titles were abolished. The state cannot award any title to any citizen except if the title is academic or military. So there are 4 provisions under Article 18. Article 18, Clause 1, which says no title except academic title or a military distinction shall be conferred by the state. So what is the state? Within the meaning of Article 12. The state cannot call somebody Sir. The state cannot confer the title of Rai Bahadur or Maharaja on any citizen of India. That is something which is not possible. But academic titles can be awarded. For example, doctor, for example, professor, it can be awarded. Military distinction can be given. For example, you are field marshal, chief of army staff, chief of defense staff, you are major, you are colonel, you are lieutenant colonel. These military distinctions can be awarded, academic titles can be awarded, but the state cannot award the titles such as Sir, Rai Bahadur, Maharaja, and others, because that would violate the principle of equality. Then Article 18 clause 2, it says, no citizen shall accept any title from any foreign state. For example, the British Queen, now the King, they give something known as knighthood, or they confer something known as knighthood. Knighthood in the sense you are now knighted. You become Sir. For example, Sir Richard Hadley, the New Zealand Kiwi fast bowler, Sir Donald Bradman, one of the prolific test batters of all time, with 99.99 average, whatever it is. So whenever somebody makes distinguished contribution to various areas, various fields, the Queen of England confers knighthood on these individuals. You will be known as Sir. Sunil Gavaskar, who became the first test cricketer to score 10,000 test runs. The Queen became very happy, and the Queen decided that we will confer knighthood on Sunil Gavaskar. So Sunil Gavaskar would be known as Sir Sunil Gavaskar. He was very happy. He stitched a beautiful, fascinating, good-looking blazer, dress, and he was all set to fly to London to accept this title so that he would be known as Sir Sunil Gavaskar. Somebody told him, Sunny Paji, what? Do you know something? He said, what? You can't accept this title. He said, why? Look at Article 18 clause 2. What does it say? It says no Indian citizen can accept any title from any foreign state. And that is how he could not accept this knighthood. That is why he is not known as Sir Sunil Gavaskar. That means not Article 18, Clause 1, Clause 2, neither can the state award title except military and academic title to anybody, nor can Indians accept titles from the foreign country. But sir, Mr. Modi has accepted the title from UAE, from Saudi Arabia. Shah Rukh Khan has accepted these titles from different countries. So has Amitabh Bachchan, so has Aishwarya Rai Bachchan. Then how are they allowed? They're allowed to accept awards. Award is not a title. You can't keep, let's say for example, Dilip Kumar. He was given Pakistan's highest award, Nishan-e-Imtiaz. But you can't use that as a title. You can't tomorrow say, I am, sir, what's your name? I am Nishan-e-Imtiaz Dilip Kumar. That doesn't happen. So title is something which appends to your name, such as I am Maharaja Digvijay Singh, I am Rai Bahadur Balram Singh, I am Sir Sunil Gavaskar. This is a title which attaches to your name. Award is not attached to your name. For example, somebody is given national award. Miss Kangana Ranaut is given national award for a particular movie. She can't go and say, Madam, what's your name? My name is National Award Kangana Ranaut. Because that's an award. It does not add to your name. It's the title which adds to your name. So those titles you cannot accept. So Mr. Modi accepting the highest civilian award from Saudi Arabia or UAE or French honor is accepted by Mr. Amitabh Bachchan or Shah Rukh Khan, but they don't use these awards as titles to their name. It's an award for their contribution. Article 18 clause 3, no person who is not a citizen of India, but this person holds any office of profit or trust under the state. For example, under the state government or under the central government, we have some foreigners working as advisors in advisory capacity. These are not Indians, these are foreigners. Can these foreigners accept titles from other countries? Yes, they can. But for that, they have to take the permission, the consent of the government, which means the consent of the President of India, which means the consent of the central government. So if there is a foreigner who is working in India, but holding a post, holding an office of trust under the government, he or she can accept the title from his own country, from any other country. But for that, you have to first seek the permission, the consent of the President of India. or you resign from this office and then take up the award, take up the title. Similarly, no person who is holding any office of profit or trust under the state, for example, you are an IAS officer tomorrow, which means you are holding an office of profit or trust under the government. You cannot, without the consent of the president, accept any present, emolument, gift from a foreign state. That is why if an IAS officer has to accept an award from a foreign state, has to accept some gift from a foreign state, from a foreign country, you have to first seek the consent of the President of India. That is Article 18 of the Constitution. So what is Article 18? Titles have been abolished. And which are these titles which have been awarded, which have been abolished? Those titles which add to your name, which act like an appendage to your name, which adds to your name. Those titles have been abolished. But military titles and academic titles can be awarded by the state. Now, there is a question which is normally asked to me by the students in the class. Sir, there is somebody, a left-arm slow bowler, a good all-rounder, Ravindra Jadeja. Sir, he is known as Sir Ravindra Jadeja. Right? How is that allowed? Article 18, Clause 1. No title shall be conferred by the state. This term, sir, was given to Ravindra Jadeja by Mahendra Singh Dhoni. Is Mahendra Singh Dhoni a state? No, under Article 12. That means tomorrow you can call me sir. Sir Sarmat Bairaj. That doesn't matter. That's not violation of Article 18. Why? Because this is the title given by the students and you are not state under Article 12. A title cannot be conferred by the state except a military title or an academic title. That cannot be conferred by the state. That is Article 18. But sir, what about Bharat Ratna? What about these Padma Awards? Padma Awards such as Padma Vibhushan, Padma Bhushan, Padma Shri. These awards were instituted in 1954. For example, Bharat Ratna is conferred on somebody who has done exceptional service in any area of human field, in any area of human endeavor. Whether you have done exceptionally in sports, in cinema, in literature, in public service, in diplomacy, in any area, if you have done exceptional service, you can be conferred with Bharat Ratna, which is India's highest civilian award, which is given to the civilians. Each year, if it is given every year, it's not necessary to give Bharat Ratna every year, but if it is given every year, maximum 3 Bharat Ratnas can be given. I'll write it down, not necessary to award each year, but if it is announced, maximum that you can award, maximum Bharat Ratnas that you can award in a particular year is 3. Similarly, these Padma Awards were also instituted, and these Padma Awards were suspended twice. Suspended twice in the sense, when 1954 these awards were institutionalized, over a period of time, we saw Pandit Nehru giving Bharat Ratna to himself. So although it was not technically Pandit Nehru giving award to himself, it was basically Bharat Ratna was awarded by the government, by the President of India. And Mr. Nehru was convinced that since you have performed extraordinary service to India, you should accept this Bharat Ratna. And some writers say he reluctantly accepted Bharat Ratna. But whether it was done deliberately or not, we don't know. Later on, Indira Gandhi gave Bharat Ratna to herself. Again, it was not Indira Gandhi giving award to herself. It was basically the government. It was basically the President of India. But be that as it may, there was an element of abuse as well. Abuse in the sense, that once in 2010, Shri Anupam Kher, he released a tweet. He said these Padma Awards have become a joke. Nobody takes these Padma Awards seriously. It depends upon the whims and the fancies of the government. If you are closer to the government, if you're parroting the words of the government, if you're supporting the government, if you're a cheerleader of the government will award you these Padma Awards, Padma Shri, Padma Bhushan, Padma Vibhushan. But I don't care about these awards. These awards have lost their whole merit. Few years later, Anupam Kher was given Padma Shri. And he tweeted, "I'm honored to receive the most important award institutionalized in India under the premiership of Mr. Modi." But be that as it may, it depends on which political philosophy you come from. If you're closer to the government, you get these awards. But in 1977, when Janata Party came to power, Janata Party suspended these awards. These awards have been misused, useless. We will not award. Then in the 1990s, constitutional validity of these awards was challenged on the grounds of violation of Article 16 of Article 18. The question before the court, in this case, Balaji Raghavan versus Union of India. In this case, the constitutional validity of these awards were challenged. The court was asked, "My lord, under Article 18, no title except which is an academic title and a military title can be conferred by the state. So here we are giving Bharat Ratna, we are giving Padma Bhushan, Padma Vibhushan, Padma Shri, and later on people use these as titles. Bharat Ratna Atal Bihari Vajpayee, Padma Shri, Shri Anupam Kher, Padma Bhushan, Shri Ravi Shankar, whatever it is. So you are using these awards as titles." Supreme Court said these Padma Awards are not violation of Article 18, because Article 18 says titles are abolished. Article 18 does not say merit should not be recognized. So if somebody has done spectacularly well in any area of human endeavor, in sports, in technology, in literature, that does not bar, does not prevent the state from recognizing this contribution. But yes, don't use them as titles. If you use them as titles, we can strip you of that title as well. Don't call yourself Bharat Ratna ABC or Padma Shri XYZ. That is something that you should not do. And that is Article 18 of the Constitution. Any questions, let me know. Then we will discuss something else. Nehru and Indira Gandhi were given Bharat Ratna? Yes. Bharat Ratna, Padma Award suspended twice? Yes. Sir, how Maharaja or Sir titles conferred by the state? If not, why they were abolished? The state cannot award these titles. State cannot call somebody Sir or Maharaja. No questions? Why Indira Gandhi resurrected these titles in 1980? Because these titles, not titles, these awards were institutionalized by her father in 1954 by the then government. So the opposition suspended these awards. When she came back to power in 1980, she restarted giving these awards. What is Office of Prophet? We will discuss it in great detail when we will discuss legislature. So in legislature, we will discuss what is Office of Prophet. IAS officers would be eligible for these awards? Yes. IAS officers are also eligible for these awards. Anybody who has done good in various fields, whether it is public service, sports, entertainment, anything, are eligible for these awards. Now let's look at another category of fundamental rights, right to freedom. And there we have to discuss Articles 19 to 22. First, we will look at Article 19, then 20, then 21, then 22. Under Article 19, it talks about protection of certain rights regarding freedom of speech. And here we have clause 1A, 1B, 1C, 1D, 1E. F was omitted, repealed by 44th Constitutional Amendment Act 1978, and this is something that we will discuss in Directive Principles of State Policy. Article 19(1)(f) basically spoke about all the citizens will have the right to acquire and dispose of property. This was omitted, repealed by the 44th Constitutional Amendment Act 1978. Why was it repealed? We will discuss that in Directive Principles of State Policy. But what Article 19 talks about, it talks about that there will be a set of rights related to freedom of speech, and these rights will be exclusively available to the citizens of India. So now Article 15, Article 16, and now Article 19. The third fundamental right, which is exclusively available to the citizens of India. And what does this Article 19 talk about? It talks about various rights which are related to the freedom of speech. We will discuss all these rights one by one, but we will spend more time on Article 19(1)(a), which is freedom of speech and expression, which is the most important fundamental right. And at the same time, this is the fundamental right which is almost always in the news, freedom of speech and expression. So first we will discuss what is this freedom of speech and expression. Then we will discuss all other fundamental rights under Article 19. What do we mean by freedom of speech and expression? Former Chief Justice of India, Justice Patanjali Sastry. Listen to me carefully. Drop everything that you are doing. This is the most important discussion that we will have now, because this article is very, very important. In fact, you should memorize this article as well. Article 19(1)(a), which deals with freedom of speech and expression. Don't ask any questions. Listen to me. Once I've completed the discussion on Article 19(1)(a), then shoot as many questions as possible, because I want your attention here, not in typing your questions. Listen to me. Former Chief Justice of India, Justice Patanjali Sastry, he said, freedom of speech lies at the foundation of all democratic organizations. For without free political discussion, no public education, which is so essential for the proper functioning of the process of popular government, no popular government is possible. How? You attend a political rally, and in this political rally, Mr. Rahul Gandhi levels some allegation. Ask the members of India, the public of India, why is the current government supporting Mr. Adani? Why some ports were given to Adani? Why some airports were given to Adani? Why there is massive exposure of public banks to the Adani group? Or why is it that some rules were tweaked by the government for Mr. Adani? Why Adani's son and his father-in-law are under the SEBI's Committee for Insider Trading? All these allegations. Whether these allegations are true or not, we don't know. But if Rahul Gandhi is not allowed this freedom to say whatever he has to say, how can we tell the public that there is an element of corruption in the society? Let's go back to 2011. It was because people were allowed freedom of speech and expression. That is how massive scams were unearthed. That is how we realize that there is a scam in the Adarsh Housing Society. That's how we realize that there is a scam in the Commonwealth Games organization. That is how we realize that there is something called a 2G scam. That is how we realize that there is something called a coal scam. That is how we realize that there were these allegations of corruption, misuse against other members of the then government. So if freedom of speech and expression is not given, and what is this freedom of speech and expression? Say whatever you have to say. Express whatever you have to express. Use any medium to express it. Whether you want to write a book, whether you want to write a song, whether you want to make a documentary, whether you want to make a movie, whether you want any other medium to express yourself, you have the fundamental right. Because if this fundamental right is not given, there can be no public education. Because in these election rallies, in these newspaper columns, every 9 o'clock on the Republic TV, the nation wants to know, if they don't have freedom to say whatever they have to say, then there will be no public education. People will not know what is happening in the country. When they will not know what is happening in this country, then there can be no proper functioning of the government. Government can do anything that it wants to do, because they would realize people will not come to know what we are doing. People will not come to know that we have indulged in corruption. People will not come to know that we have taken a decision to favor somebody. And that is why we say, according to former Chief Justice of India, Justice Patanjali Sastry, freedom of speech, where you say whatever you have to say, openly, without any favor, without any fear, without any threat, it lies at the foundation, at the heart of all democratic organizations. And without this freedom, there can be no public education. And when there is no public education, then proper functioning of the government is not possible. That is the significance of freedom of speech and expression. Something else. We say freedom of speech and expression, this fundamental right under Article 19(1)(a) is the second most evolved fundamental right. And what is known as second most evolved fundamental right? This is where we come across a term known as judicial creativity. What is judicial creativity? For example, Article 21 of the Constitution, which if possible we will discuss today, if not then tomorrow. Article 21, very briefly, it talks about right to life and personal liberty. That's it. Right to life and personal liberty, that's your fundamental right. But this innocent looking article, this innocent sounding fundamental right, right to life and personal liberty, judiciary has used its creativity, has expanded the scope of Article 21 and has given us those fundamental rights which were not originally part of the Constitution. So if Article 21 only said right to life and personal liberty, judiciary used its creativity and judiciary said right to clean environment is also a fundamental right under Article 21. Right to privacy is also a fundamental right under Article 21. Right to travel abroad is also a fundamental right under Article 21. Right against torture is also a fundamental right under Article 21. Right to livelihood is also a fundamental right under Article 21. Right to housing is also a fundamental right under Article 21. That means judiciary has used its creativity, expanded the scope of Article 21, which originally said that you have only right to life and personal liberty. Now a whole list of fundamental rights have been derived from Article 21. So under Article 21, now we have a big list of fundamental rights, which originally was not mentioned in the Constitution. But these fundamental rights were derived from Article 21 by an independent judiciary using its judicial creativity. And the highest number of these derived rights, whom what we call are inferred rights. What is an inferred right? There is a statement given. What do you infer from the statement? There is a right given. What are the other rights that you can infer from this fundamental right? Those are what we call inferred rights. And the highest number of inferred rights have been conferred by the Supreme Court using Article 21's interpretation. That is what we say. Article 21 is the most evolved fundamental right. Under this Article 21, the highest number of rights, inferred rights, have been evolved. And the second highest number of inferred rights, second most evolved fundamental right, is freedom of speech and expression under Article 19(1)(a) of the Constitution. What are these inferred rights? For example, there is something known as Flag Code of India. Previously, this Flag Code of India would have said that you can hoist the national flag only when there is a Republic Day or when there is an Independence Day, not on other days. You can hoist this national flag only at the top of the government office. Can be parliament, can be secretariat, government offices, not private offices. One politician, Naveen Jindal, from the Congress party, approached the Supreme Court and asked the Supreme Court, "Dear Supreme Court, do I have the freedom of speech and expression?" Court said, "Yes, you have the freedom of speech and expression. But why are you here?" "Sir, I want to express my love for my country." Said, "How?" "I want to express my love by flying the national flag at the top of my home, at the top of my private office. I want to fly the national flag every day. Why only on specific days? I want to wear a badge of the national flag close to my heart. That's how I want to express my love for my country." The Supreme Court said flying of the national flag is the symbol of expression, and it is a fundamental right under Article 19(1)(a) of the Constitution. So Article 19(1)(a) only spoke of freedom of speech and expression. Now, judiciary, using its judicial creativity, has expanded the scope of Article 19(1)(a) and has given another inferred right, saying flying the national flag is also a fundamental right under Article 19(1)(a) of the Constitution. Matter went to the court again, and this time an organization known as ADR, Association for Democratic Reforms, which is a non-governmental organization which works in the field of electoral reforms. They are basically pressure group. They're trying to pressurize the government to have some kind of good reforms in elections. Association of Democratic Reforms approached the Supreme Court. "Dear Supreme Court, do I have the freedom of speech and expression?" Court said, "Yes, you have the freedom of speech and expression. Read the Constitution. Why are you here?" "Sir, does that mean I have the right to ask questions as well?" And now you're coming to the point. So you're saying you have freedom of speech and expression. Yes. Freedom of speech means say whatever you have to say. Said, "Yes." Which means you can also ask questions. "Yes, but what sort of questions do you want to ask?" "Sir, I want to ask questions to those candidates who are contesting elections." Like what sort of questions? Like, what is your educational qualification? Okay. How many criminal cases are pending against you? What is the amount of assets in your name and in the name of your spouse? I want to ask these questions to the Supreme Court. I want to ask these questions to the candidates contesting elections. Said, "You have the freedom of speech and expression." "Yes." Which means you can say whatever you have to say. "Yes." Which means you can also ask questions because that's also speech. And you are saying that we should be asking questions to the candidates contesting elections, such as what is your educational qualification? What is your criminal background? How many criminal cases are pending against you? What is the amount of assets in your name, property in your name, and in the name of your spouse? Yes, you can ask these questions, but what is the purpose? Sir, I want people should have the right to this information. Okay, people should have the right to this information, but why? What is the objective that you want to serve? Because the people should have the right to make an informed choice. And what is this right to make an informed choice? You have to make a choice. What is the choice? You are preparing for the civil services examination and you want to enroll in a coaching program. There you have BYJU'S, CJU'S, TJU'S, any JU'S. Clear? And now you have to choose amongst these institutes. How can you make this choice unless and until you have the information? I will tell you that we will give you these live classes. Others will tell you we will also give these live classes. I will tell you one more information. These are the teachers that we will have. We will give you weekly tests as well. They will give some other information. Others will give some other information. So once you have information about all these 4 institutes, then you can make a right choice. You can make an informed choice. That means you can make a choice based on the information. Sir, when people have to vote, how can people choose one candidate as against the other? For that, the people should have the information about all the candidates. That is what we are seeking. All the people of this country, under Article 19(1)(a) of the Constitution, which talks about freedom of speech and expression, they should have the right to such information as well. Because when the people have information about these things, then they can make an informed choice. Then they will decide whether they want to vote for Rahul Gandhi or they want to vote for Mr. Modi. The Supreme Court said this right to information, particularly a voter's right to know the antecedents, the assets of a candidate contesting election. This is also a fundamental right under Article 19(1)(a) of the Constitution. In another matter, a matter was filed in the Supreme Court. Sir, we have right to freedom of speech and expression. That means the right to say something. I said, yes. Does that mean we also have the right to remain silent? I said, how? I said, noise pollution. There is blazing pollution in our neighborhood, and this is disrupting my peace. I want to remain silent. When I want to remain silent, that means I want my surroundings to also be silent. So you are saying something convoluted, something conflicting. I said, sir, I'm simply saying, do I have the freedom of speech and expression? Yes. That means I have the power, the right to say whatever I have to say. Yes. Do I have the right to remain silent as well? If the police is arresting me, I will not say anything because that will be held against me in a court. That can be used as an evidence that you have accepted your crime. Do I have the right to remain silent? Yes. That right to silence is a fundamental right under Article 19(1)(a). Sir, but not only this silence of the airs as well. There is blazing pollution coming from the other side. Should there be a limit to when the loudspeakers can be used, when the loudspeakers cannot be used? Because that disturbs my sleep cycle as well. Supreme Court said this right against noise pollution is also a fundamental right under Article 19(1)(a) of the Constitution. That means this innocent looking article, freedom of speech and expression, although it only talks about freedom of speech and expression, but other rights which originally were not part of the Constitution, were not part of Article 19(1)(a), they have been given to the citizens by the judiciary by using its judicial creativity. Something else as well. If we look at United States, it explicitly talks about freedom of press. Freedom of press means newspapers have the right to publish whatever they want to publish. Mr. Goswami has the right to say whatever he has to say on the nation wants to know. This freedom of press is explicitly mentioned as a fundamental right in US Constitution, but it was not mentioned in India. Matter went to the court. My lord, do we have the freedom of speech and expression? Yes. What about press? Freedom of press is not mentioned in the Constitution. Court said, so what? Freedom of press is also a fundamental right under Article 19(1)(a) of the Constitution. And that is why we say Article 19 is such an important fundamental right. And it is the second most evolved fundamental right, under which the second highest number of inferred rights have been conferred on the citizens of India. Freedom of speech and expression. But this freedom of speech and expression is not an absolute fundamental right. So it's like the example that I gave you 2 days ago, that your dad is giving you 1,000 rupees. It's your pocket money. Thank you, dad. You are the best dad in the world. That I know. Now use this money to pay the electricity fee. That means on one hand, your dad is giving you money to spend, and on the other hand, he is asking you to spend for himself or for the family, basically snatching this money from you. So on one hand, the Constitution of India has given under Article 19(1)(a) freedom of speech and expression. The very next article, 19 clause 2, imposes reasonable restrictions on your freedom of speech and expression. And now let's look at what are these reasonable restrictions. What are these grounds on the basis of which your freedom of speech and expression can be restricted? One ground is sovereignty and integrity of India. And to tell you, this was not an original restriction mentioned under the Constitution. Original Constitution did not impose a restriction on your freedom of speech and expression in the interest of sovereignty and integrity of India. This reasonable restriction was introduced in 1963 by 16th Constitutional Amendment Act. That means say whatever you have to say, but you cannot go against the sovereignty and integrity of India. So in the interest of sovereignty and integrity of India, your freedom of speech and expression can be restricted. Second, in the interest of the security of the state. Sir, what is the security of the state? Let me give you one simple analogy. For example, this is line of actual control between India and China. I'm telling you, I'm giving you a hypothetical situation so that you understand what is the security of the state. There is line of actual control between India and China. Now we realize that China is an expansionist state. It wants to expand its territory. That's how it expanded into Tibet. That's how it wants to completely take over Taiwan. It wants to take over completely Hong Kong, so on and so forth. And it wants to take over Arunachal Pradesh. It wants to take over Ladakh. That's the expansionist nature of Chinese state. But the point is, now the Indian government is planning an operation that all those territories which have been illegally snatched by China, we want to launch a military operation or an air force operation to reclaim these territories illegally captured by China. Now suddenly there is a journalist who gets to know about this operation, and he wants to publish this on the front page of the Hindu newspaper so that we can discuss in the daily Hindu newspaper analysis. Clear? Now this journalist, when he's trying to publish the story, this story is banned by the government. Take down the story, don't publish the story, matter will go to the court. Journalist will claim, my lord, my fundamental right has been violated. Which fundamental right? Freedom of speech and expression. It's such an important fundamental right. Please come, please come. Government, why have you violated his freedom of speech and expression? Yes, sir, we have violated, but it is in the interest of the security of the state. What sort of interest? Sir, he was publishing a story where he talked about our ongoing military operation against China. If the Chinese authorities will come to know, they will mount a defense. They will tackle our operation. So it is for the security of the state that we are telling them, don't publish the story, don't broadcast the story, block the story altogether. The court will say this is a reasonable restriction. This is not an unreasonable restriction, because you have the freedom of speech and expression, but it is not an absolute fundamental right. You can't say anything that you have to say. There has to be some reasonable restriction on your freedom of speech and expression. One such restriction is, don't say anything which goes against sovereignty and integrity of India. Don't say anything or don't write anything which goes against the security of the state. Third restriction, friendly relations with foreign states. For example, the Sultan or the Prince of Saudi is coming to India. MBS, Mohammed bin Salman, who is considered to be the de facto ruler of Saudi Arabia. But according to reports, he's also a murderer. Murderer in the sense, whether that's true or not, we don't know, but the allegation is that he directly ordered the killing of a Washington Post journalist, Jamal Khashoggi. Basically a Saudi citizen, but was staying in the United States of America. He wrote articles criticizing Mohammed bin Salman, but then he was in Turkey and he approached the Saudi embassy in Istanbul, in Turkey's capital, and he wanted to renew his visa. As soon as he entered the embassy in Istanbul, he never came back. And it is argued that Mohammed bin Salman had sent his secret troops inside the Saudi embassy in Istanbul. Jamal Khashoggi was killed. Then his body parts were cut into smaller pieces, dropped in a handbag, and then this handbag with the body parts of Jamal Khashoggi were taken out. What if Mohammed bin Salman comes to India and then there are Indians who are protesting against Mohammed bin Salman, saying you are a murderer, you are a horrible person, you are depriving Saudis of their rights, anything for that matter. Now here Mohammed bin Salman will tell Mr. Modi that, why did you call me here? You wanted cheap oil, that's why you called us here. You wanted investment, that's why you called us here. You wanted some help, financial support, that's why you called us here. But we will not have any dealings with you. Look at what your country is doing. Look at what your people of this country is doing. They are anti-us, they are anti-me. I will not support you. So in the interest of friendly relations with foreign states, Mr. Modi can say, ban all these protests against Mohammed bin Salman. Stop all these articles against Mohammed bin Salman. That can happen. Why? Because in the interest of friendly relations with foreign states, there can be reasonable restriction on your freedom of speech and expression. But this restriction was not originally part of the Constitution. It was added to the Constitution by the first Constitutional Amendment Act 1951. So the first Constitutional Amendment Act made a lot of changes to the Constitution. One such change was, through this amendment, another reasonable restriction was imposed on your freedom of speech and expression. That means on the grounds of friendly relations with foreign states, your freedom of speech and expression can be restricted. Ground number 4, public order. And what is this public order? For that, we need to understand the background. Bombay Mirror. It was a magazine which was published from Bombay. It had to be transported to Madras as well. The state was Madras. Matter went to the court. Why? Because the Madras government had stopped the circulation of this magazine. Why? Because this magazine had some revolutionary content. And this revolutionary content would have violated public order. What does that mean? Bombay Mirror, a magazine published from Bombay, and you had to circulate this and send to different parts of the country, including Madras. And in Madras, this magazine was banned. Its circulation was stopped. One communist leader approached the Supreme Court and asked the Supreme Court, how can Madras government ban this magazine? Madras government was asked, how can you ban this magazine? Madras government said the content of this magazine is revolutionary, in a sense that it can incite violence in the society. In the sense it can violate public order. That means there will be loss of peace in Madras. That is why we have banned it. The Supreme Court said you can't do that. Why? Because there is no such reasonable restriction known as public order under the Constitution. Constitution can only impose restriction on your freedom of speech and expression on the grounds of security of the state. On the grounds of the security of the state, there can be limitation, the restriction on your freedom of speech and expression, not on public order. And ultimately, this magazine was allowed to be circulated in Madras and other states of India. But then Parliament realized that we need to impose restriction on your freedom of speech and expression in the name of public order. Public order in the sense, hate speech. Does freedom of speech and expression give you the power to indulge in hate speech as well? That means I have the freedom of speech and expression. I can say whatever I have to say. Do I have the power to say something which will lead to a situation of hate within the society? I'm inciting one group that you should hate the member of another community, or you should hate the people speaking a different language, or you should hate people wearing a different dress or eating a different kind of food. Does the Constitution allow freedom of speech and expression in such a manner that it allows you to practice hate speech as well? No. You have freedom of speech and expression, but that comes with reasonable restrictions. If this Bombay Mirror indulges in hate speech, indulges in a freedom of speech and expression which incites and violates public order in the society, but there was no ground that on public order, your freedom of speech and expression can be restricted. Parliament said, let's amend the Constitution. First Constitutional Amendment Act 1951. Let's add public order as a ground, as a reasonable restriction under Article 19, Clause 2 of the Constitution. So now your freedom of speech and expression can be restricted in the interest of sovereignty and integrity of India, in the interest of the security of the state, in the interest of friendly relations with foreign states, and for upholding public order as well. 4 grounds on the basis of which your freedom of speech and expression can be restricted. 5th ground is decency or morality. What is decency or morality? We say decency is same as lack of obscenity. You have the freedom of speech and expression. Does that also include that you can make pornographic content? Does that mean you can sell pornographic magazines? That is not the fundamental right available to you. Because you have the freedom of speech and expression, but it can be restricted on the grounds of morality or decency. You can't publish obscene content. You can't indulge in child pornography or an adult pornography. That's a crime. Your freedom of speech and expression will be restricted. But here we need to understand that the concept of morality keeps on changing. What was immoral in early 1950s or 60s, that is completely moral today. What was and what is immoral today may be completely moral tomorrow. So how do we judge, how do we test this concept of morality? Is this age-old morality or the morality which was present in the society at the time of the commencement of the Constitution? Or is it the contemporary morality? Morality of the society as we can see today in the contemporary times. For example, if you look at the movies, If you look at the cinema of 1950s and 60s or even 70s, if there was a romantic scene to be displayed, to be depicted between the two actors, this romantic scene was displayed by the kissing of the two flowers. Over a period of time, we saw a full-blown kissing scenes in the movies. Why? Because the morality keeps on changing. What is immoral then is completely moral now. What is immoral today may be completely moral tomorrow. And this is where there is a recent current affairs development on this. Lady Chatterley's Lover. This is one movie which is released recently on Netflix, and it has a history to India. One of the most landmark cases on freedom of speech and expression in India, Ranjit D. Udeshi versus State of Maharashtra. Lady Chatterley's Lover, it was a novel written by W.H. Lawrence, and it was at that time considered to be an erotic novel. And it was banned in various countries of the world. When this Chatterley's Lover was to be imported in India, it was also banned. It was banned in India as well. Why? Because it was immoral. It was obscene. It lacked decency. And on the grounds of morality or decency, your freedom of speech and expression can be restricted. Freedom of speech and expression also means that I have the right to read books. I have the right to seek information. I have the right to impart information as well. That's part of my freedom of speech and expression. But this can be restricted on the grounds of morality or decency. Ranjit D. Udeshi, he had imported some copies. He was a publisher, distributor. He had imported some copies of this erotic novel, Lady Chatterley's Lover. And these copies were confiscated and they were not allowed to be sold. He approached the court and the court said and invoked a principle known as Hicklin test. What is this Hicklin test? If we look at the entire book, even if the entire book is good, normal, no erotic language whatsoever, but there is only one part in this book which lacks decency or which is immoral, the entire book can be banned. If there is a movie, the entire movie is of 120 minutes. 110 minutes are normal, completely fine, completely okay. Only 10 minutes are obscene. The entire movie can be banned according to Hicklin test. That means we have to look at entire movie in parts as well. Even if there is a part which is immoral, you can ban that movie, you can ban that book. And Supreme Court invoked this Hicklin test and said even if there are some portions of this Lady Chatterley's Lover which are immoral, which are obscene, we will still go ahead and ban the entire book. And now this Lady Chatterley's Lover, it has now been released on Netflix as a movie. The point is, your freedom of speech and expression can be restricted on the grounds of morality or decency. This is the fifth ground on the basis of which there can be restriction on your freedom of speech and expression. Any questions as of now? How many need a break? Couple of students. Okay. 7:55. Let's meet at 7:50 a.m. and discuss the remaining provisions of Article 19. See you on the other side. Shall we continue? Article 19 talks about freedom of speech and expression. And there we have a 6 set of fundamental rights. First one is 19(1)(a), which deals with freedom of speech and expression. What is this freedom of speech and expression? Say whatever you have to say, express whatever you have to express, use whichever medium you want to express. You have the fundamental right to do that. That's what we call free speech. Without any restriction, without any limitation, say whatever you have to say. But then Constitution under Article 19 Clause 2 imposes reasonable restrictions on your freedom of speech and expression. Number one is in the interest of the sovereignty and integrity of India. Number two, security of the state. Number three, friendly relations with foreign states. Number four, public order. Number five, morality or decency. Number six is contempt of court. And on this ground also, reasonable restrictions can be imposed on your freedom of speech and expression. What is this contempt of court? We can broadly classify contempt of court into two groups. Either it is civil contempt or it is criminal contempt. Civil contempt is something which is taken sometimes lightly by the courts, and it is this criminal contempt which is taken very seriously. What is a civil contempt? For example, this is a property and you and me have a dispute. Who owns this property? Matter goes to the court. The court says it is your property, it is not my property. Now the court is asking me to vacate. If I disobey the court order and I do not vacate this place, what am I doing? I am committing contempt of court. I am willfully, deliberately disobeying the court order. That's what we call civil contempt. Civil contempt is taken lightly by the courts. For example, don't do it again, otherwise we will arrest you, because that's not the power that you have. You cannot disobey us because we are the final authority. Or for example, basically you are committing willful breach of an undertaking given to the court. What is the undertaking? For example, you and me have a dispute. I owe you 1 crore rupees. And now the matter is before the court. I am giving an assurance to the court that before 10th of February, I will give 1 crore back to this individual. That means I'm giving a written assurance, an undertaking before the court that I will repay you that money. If I'm deliberately not doing that, I'm committing contempt of court, which is what is called as the civil contempt. But criminal contempt is something dangerous, which means when you publish something and you try to scandalize the court, you try to prejudice or interfere the court, you are interfering or obstructing the justice. That is what we call criminal contempt. And what is criminal contempt? I'll give you a few instances. For example, Mr. Prashant Bhushan, a noted lawyer, an RTI activist as well, he tweeted something. What did he tweet? He said that we have the Chief Justice of India, S.A. Bobde, who was then the Chief Justice of India. S.A. Bobde is riding a motorcycle, and this motorcycle belongs to the BJP leader, and you're riding this motorcycle in Nagpur. What is the significance? I'll tell you. At a time when the Chief Justice of India has locked the Supreme Court. This is the tweet of Shri Prashant Bhushan. What is he saying? He is expressing himself. That's his freedom of speech and expression. You are saying something. What are you saying? You are saying that the Chief Justice of India is riding a motorcycle which belongs to a BJP leader, that too in Nagpur, at a time when the world is under a lockdown. He has locked down the Supreme Court. He is not allowing the physical hearing in the Supreme Court, and he's riding this motorcycle without a mask. This was the tweet of Prashant Bhushan. And then a case of contempt of court was filed against him. On what grounds? You're scandalizing the court. Scandalizing the court in the sense, you're sowing the seeds of distrust amongst the members of the society, amongst the people of India. So through this tweet, you're saying that people should get this reference that this Chief Justice of India is close to the ruling party, which is the BJP, and he's riding this motorcycle in Nagpur, which is the headquarters of the RSS, which means you're trying to give a sense to the people that the current Chief Justice of India is closer to the ruling party at the center. At the same time, it is closer to its ideological parent, which is the RSS. So we should not trust the judiciary. Judiciary is all about trust. We say Supreme Court is final, not because it is right, but Supreme Court is right because it is final. Yes, Supreme Court in its judgments may make mistakes, but there has to be a final authority which can put an end to a particular case. And that final authority is the Supreme Court. And the Supreme Court, we can't say that it is infallible. We can't say that Supreme Court will not make mistakes in its verdicts, in its judgments. But we should still respect the Supreme Court judgment because it is the final authority of justice. Now, if we start attributing motives to the Supreme Court, do you know why Supreme Court gave this verdict? Because the judges are Brahmins. Do you know why Supreme Court gave this verdict? Because they took money from Mr. Adani. Do you know why Supreme Court gave this verdict? Because they are closer to the BJP government at the center. If you are sowing these seeds of distrust, mistrust amongst the people of the society, they will not trust the Supreme Court. So if you are using your freedom of speech and expression to scandalize a court, that the court is corrupt, that they have taken money in order to give this verdict, that they are casteist, that they are communal, that they belong to the ruling party. Through this, you are sowing the seeds of mistrust, distrust amongst the members of our community, of our society, then people will not trust the judiciary. This is criminal contempt. You are scandalizing the court. You tend to scandalize the court, through which you want to lower the dignity of the Supreme Court. And that is how Prashant Bhushan was convicted for contempt of court, and a fine of ₹1 was imposed on Prashant Bhushan. One more important thing. Under contempt of court, who can file a case? Who can file a case? One, Attorney General for India. Second, Supreme Court can suo motu, on its own take up the case. Third, a third person. Clear? Who can file a case? For example, if somebody has said something which is contempt of the Supreme Court, Attorney General himself can approach the Supreme Court. Dear Supreme Court, please punish that individual because he has committed contempt of court. If not, then it can be a newspaper article, or it can be a tweet, or it can be a song which can be written by somebody. Supreme Court judges read this on their own. They file a criminal contempt court case against this individual. That means second way by which a contempt of court case can be filed against an individual, if the Supreme Court itself on its own, without somebody approaching the Supreme Court in itself is launching contempt of court proceedings against you. Or a third person in the sense, Kunal Kamra has said something. What has he said? That the doors of the Supreme Court are open for the wealthy sections of the society. They're not open for the weaker sections of the society. Why is it that the court is giving enough opportunity first opportunity to Arnab Goswami to file a case for his bail application where thousands are languishing in the jail. So Supreme Court is like the air hostess, which is giving champagne to only the first class passengers. And while the other sections of the society, they're struggling to board a plane. That was his allegation. Who can file a contempt of court case against Kunal Kamra, the comedian? Either it is the Attorney General for India who can approach the Supreme Court, look what Kunal Kamra has said. That means this is how the case can be filed. Or Supreme Court will itself look at this tweet and on its own start criminal contempt of court proceedings against Kunal Kamra. Or it can be a third person. It can be you, it can be me, it can be somebody. If you want to approach the Supreme Court and file criminal contempt case against Kunal Kamra, then you have to seek the permission of Attorney General. That means unless and until permission is given by Attorney General for India, you cannot approach the Supreme Court and file this petition of contempt of court. And this protection is given to save the time of the court. What do we mean by to save the time of the court? For example, you have said something which is contemptuous, which basically lowers the dignity of the Supreme Court. You are alleging that Supreme Court judges are biased. These are biased against women community. These are misogynist, or these are communal, or these are casteist. If I want to approach the Supreme Court, look what this person is doing. Look what this person has said. He has violated freedom of speech and expression. He has committed contempt of court. I have to first approach the Attorney General for India. Please give me consent so that I can approach the Supreme Court. Why Attorney General is involved here? To save the time of the court. Because Attorney General will look at your statement. And if Attorney General is satisfied that yes, this indeed is a contemptuous statement, this indeed you have committed contempt, then you can file a case in the court. Because then it's a genuine case. And then the Supreme Court will hear this matter. They would have this presumption that yes, there is an element of contempt involved. Otherwise, if every single time of contempt of court case is filed in the court, the Supreme Court will have to first decide whether it is indeed contemptuous or not. It wastes a lot of time of the court. That is why without Attorney General's permission, you cannot approach the court and file the petition of contempt of court. Clear? But then, can you not criticize the judgments of the court? Can you not heavily criticize the judgments of the court? If the Supreme Court has given a wrong verdict, a bad verdict, a horrible verdict, should as citizens we not be able to criticize it? That should be part of our freedom of speech and expression. That is why in the year 2008, 2006, two important amendments were made. Amendments to what? Criminal Courts Act 1971. Criminal Contempt of Court Act 1971. Two important amendments were made in 2006. Amendment number 1, no criminal sanction can be imposed for contempt. You cannot be prosecuted for contempt unless and until the court is satisfied that you have substantially interfered or you tend to interfere with the due course of justice. Second, if the court permits truth as a valid defense in public interest or bona fide. What does that mean? The Supreme Court in Ayodhya case in 2019 said that this dispute where 2.77 acres of land was to be decided. Who owns this 2.77 acres of disputed land at Ayodhya where once Babri Masjid stood? The Supreme Court ruled that this land belongs to Lord Ram, and that is how a mega Ram temple can be constructed at Ayodhya. The Supreme Court further said that 5 acres of land should be given to Muslims, to the Muslim Waqf Board, somewhere else in Ayodhya, so that if they want, they may set up a mosque there. Because Muslims have been deprived of their place of worship, which is the Babri Masjid. But since this land belongs to Lord Ram, this land will be given to the Hindus. An alternate 5-acre land will be given to Muslims, where if they want, they may construct a mosque. What if somebody, you and me, we together, we go to Ayodhya and we block the construction of Ram temple? We say, no, we will not allow the construction of the Ram temple. Or we go to that site where 5 acres of land is given to the Muslims. We'll say we will not allow Muslims to construct a mosque or a hospital which they're trying to construct. We will not do that. So you are interfering with the course of justice. You are substantially interfering with the court, with the course of the justice. Here, contempt of court case can be filed against you and you can be arrested as well, because you are interfering with the course of justice. If the justice has been given by the court and you are trying to block it, this is contempt. But unless and until you are substantially trying to block justice, you're only saying that this judgment is wrong because of these reasons. This judgment should not have been given because of these reasons. You're not interfering with the course of justice. You're not blocking the course of justice. You're just giving your opinion. You will not be prosecuted. And second, if what you are saying, if you are criticizing the court, but you are criticizing on the grounds of truth, even then no action can be taken against you because you are saying truth in the larger public interest. Genuine interest you have in speaking the truth. To understand this, let's take an example. The year was 2013, January 2013 to be precise. What was the case? The case was of Moninder Singh. Moninder Singh was living in Punjab, and according to the allegation, he raped his daughter. When he raped his daughter, matter went to the Punjab High Court. Punjab High Court said this is rarest of the rare case. Death sentence should be awarded to Moninder Singh. Moninder Singh then approached the Supreme Court. And Supreme Court said, no, this is not the rarest of the rare case. No death sentence. We will give life imprisonment to Moninder Singh. Okay, life imprisonment was given to Moninder Singh. Moninder Singh was in the jail. But even if you are in jail, you can be released for some days and then you have to go back to the jail. That's what we call parole. So Moninder Singh was released on parole for a few days. After that, he had to go back to the jail. When Moninder Singh was released on parole, he killed the daughter he had raped. He also killed his wife. While on parole, he killed the daughter he had raped. He killed his wife as well. Matter went to the Punjab High Court. Punjab High Court said, now nobody can save you. You are to be hanged by your neck till death. Moninder Singh approached the Supreme Court, and 2 judges of the Supreme Court in January 2013 said, no death sentence. Award life imprisonment to Moninder Singh. Why? Because Moninder Singh may be a threat to his family, but he is not a threat to the society. In any case, it is not the rarest of the rare case. So we will not give death sentence to Moninder Singh. We will award life imprisonment to Moninder Singh. One judge was Justice Satasivam. The other judge was Justice Khalifullah. These judges were then part of another bench in the 3rd week of January, same year, 2013. Now they had to discuss another case. They had to hear another case. And what was that case all about? This time a 7-year-old boy was kidnapped. And then the 7-year-old boy was also killed. The accused, who was arrested in this case, where it was proven that yes, this person had kidnapped the 7-year-old boy, had killed the 7-year-old boy as well, these judges said this is rarest of the rare case. Rarest of the rare case, death sentence should be given to this accused. Death sentence should be given to this convict. Many things were said by the court, but one peculiar thing was said by the court. One disturbing thing was said by the court. The court said, this is rarest of the rare case. Why? Because imagine the plight of the family, which has lost their only male child. And this male child would have carried forwarded their family lineage. So since this is the kidnap and death of 7-year-old boy, who is the only male child of his parents, who would have carried forwarded his family lineage, that is why this is the rarest of the rare case. Death sentence should be given to this convict. various journalists, writers, activists, they wrote scathing articles criticizing the Supreme Court, accusing the Supreme Court of patriarchy. That out of these two cases, because the same judge is hearing these two cases, in one hand, there is a case involving the death, murder of the daughter as well as the mother. And the other case involves the death and the kidnap of a boy. Both are horrific crimes. But if you have to pick and choose, which of these two crimes is more horrific? Which of these two crimes should satisfy rarest of the rare doctrine? It should ideally be the killing of the wife and the daughter whom he had raped. So the judiciary was accused of being patriarchal, of being biased in favor of a male child. And then a case was filed in the court that these writers, they are committing contempt of court. They are scandalizing the court. They tend to scandalize the court. They are lowering the dignity of the court by calling the Supreme Court patriarchal. But then the Supreme Court was told that all these are part of facts. This is truth. We are not cooking stories on our own. You have mentioned in your judgment that this is the rarest of the rare case because it involves the killing and kidnap of 7-year-old boy who would have carried forward their family lineage, who was the only male child of his parents. So we are saying anything, but that is truth. So truth is a valid defense. Even if you are criticizing the court, you are lowering the dignity of the court, you are violating the Supreme Court, but it is based on truth. Truth is your defense. You cannot be booked for contempt. You cannot be punished for contempt because truth is your shield. But long story short, you have the freedom of speech and expression, but then reasonable restrictions are imposed on your freedom of speech and expression. Which are these reasonable restrictions? In the interest of the sovereignty and integrity of India, in the interest of the security of the state, in the interest of friendly relations with foreign states, for public order, contempt of court, morality or decency. These are the 6 grounds on which your freedom of speech and expression can be restricted. 7th ground is defamation. Sir is not teaching well. Okay, that's an opinion. Sir is a murderer. Sir is a terrorist. You're defaming me. Do you have the right to say whatever you have to say, but at the same time defame somebody? Violate their reputation? I have the fundamental right to my dignity. I have the fundamental right to my reputation as well. If you are saying something which is truth, if indeed I'm a murderer, if indeed I'm a terrorist, then you're saying the truth. You have the free speech, say it. But if I'm not the murderer, and I'm not the terrorist, and you're calling me murderer or the terrorist, I will drag you to the court. Why? Because you have violated the freedom of speech and expression. You are saying something which is defamatory. And defamation can be of 2 types. Either it can be a libel or it can be slander. Libel in the sense, something that you write. If through your writing, through your article, through your book, you are defaming me, that's what is called as libel. But if through your speech, through your spoken words, you are saying something at a rally, if you're saying something which is defamatory towards me, that is what is called as slander. Right to free speech does not entitle one to violate the rights of others. I have my own rights, you cannot violate them. Your freedom of speech and expression ends where my dignity starts. So you have the free speech, say whatever you have to say, but say the truth. Don't defame somebody. And the 8th restriction on your freedom of speech and expression is inciting people to an offense or inciting people to violence. I give a rally, all you people, what you should do, you should keep your knives, you should keep your weapons, and we have to kill every single member of a particular community. That means I'm saying something, but through my speech, I'm inciting people to commit an offense. I'm inciting people to violence. This is not protected free speech. This free speech is not protected because you are inciting people to violence. This is the 8th ground on the basis of which reasonable restriction is imposed on your freedom of speech and expression. Because the court has said that it is very important in state of Bihar versus Sheila Bala Devi, that incitement to murder or any violent crime, it would generally endanger the security of the state as well. And if you're inciting people to violence, you're violating public order, you're violating the security of the state, you're violating the peace and tranquility in the society. These are 8 reasonable restrictions on your freedom of speech and expression. For example, the BBC documentary, India, the Modi Question, using IT rules of 2021, using section 69 capital A of Information Technology Act 2000, this documentary was banned in India. Why? Because any documentary which goes against the sovereignty and integrity of India can be blocked, can be stopped from streaming. But whether this is a genuine use of power or abuse of power, that's for the Supreme Court to decide. And now Supreme Court will decide whether this banning of this documentary, whether it is correct or incorrect, constitutional or unconstitutional. That is for the Supreme Court to decide. Which means if your fundamental right is violated, you can directly approach the Supreme Court. And Supreme Court will decide whether your fundamental right has been reasonably restricted or there is unreasonable restriction on your freedom of speech and expression. That is Article 19(1)(a) of the Constitution. Any questions as of now? Let me know. If criminal contempt is very dangerous, then why only rupee fine was imposed on Prashant Bhushan? Because Attorney General then, Mr. K.K. Venugopal, he persuaded the Supreme Court that yes, Mr. Prashant Bhushan has committed contempt of court, but please look at his history as well. He's a very bona fide lawyer. He's taking a lot of cases without charging any fee, taking up the cases of the weaker sections, marginalized sections of the society. So he has done a lot of good things for the dignity of the Supreme Court as well. So we should give him an opportunity. Let's not impose strict punishment on him. Let's impose a token punishment of rupee 1. And the Supreme Court agreed. Then what about sedition, which comes under section 124 capital A of Indian Penal Code? What is sedition? For that, we need to understand what is the text of sedition. Whoever, by words, either spoken or written, or by signs, or by visible representation, such as cartoons, if you bring or attempt to bring into hatred or contempt, or excite or attempt to excite disaffection towards the government established by law, then you have committed sedition. And then you can be sentenced to 3 years in jail as well. This is what is called sedition. So what is sedition? If you're using your freedom of speech and expression, if you're saying something, writing something, drawing a cartoon, and through which you are promoting disaffection, not against the nation, against the government established by law, you have committed sedition. When was this section introduced in India? The year was 1870. In the year 1870, section 124 capital A was introduced into the Indian Penal Code. What was the purpose? The purpose was to prevent the nationalist movement of freedom from going to the public. What does that mean? India was a colony of the British Empire. But when for years and years and decades, people were governed by the British, governed by an alien power, people did not even realize when they were free, because they never saw the free environment. They were always under the British occupation. So we had to convince people, we had to educate people first that look, my dear, look, the people of India, you are not independent, you are not sovereign, you are ruled by a foreign country, you are ruled by a foreign government. This is an alien government and we have to overthrow this alien government. For that, speeches were given, rallies were conducted, pamphlets were distributed, books were written. When the British realized that there are people in India who are writing something, who are giving rallies and speeches, and through this they are trying to promote disaffection against us, and we are the government of India, government established by law, we should punish these people. So that if we are allowing them to say whatever they have to say, they will convince the people that you should revolt against us, and then we are gone. So the basic purpose why section 124 capital A was introduced into the Indian Penal Code was to prevent the nationalist freedom, nationalist movement for freedom in India. And that is how under section 124 capital A, Lokmanya Tilak was arrested. Mahatma Gandhi was arrested because they were trying to promote disaffection against the government established by law. Once the constitution was framed, once the constitution was being decided upon, drafted, the members of the Constituent Assembly thought, and they decided and debated whether sedition should continue as the reasonable restriction on your freedom of speech and expression or not. That means we have the freedom of speech and expression, but should we restrict people from promoting disaffection against the government established by law? Initially, it was thought that yes, sedition should be a reasonable restriction. That means you can't say whatever you have to say and promote disaffection against the government. But then the members of the Constituent Assembly, they thought, no, we have to give this power to the people. If the government is not working for them, they have to promote disaffection against this government. Government should not be conflated with the nation. Nation is something else. Nation is above everybody. Government has to work for the people. If you are promoting disaffection against the nation, that we will not allow, because then you are going against the sovereignty of India. But you can always promote disaffection against the government. If the government is corrupt, if the government is unable to give you justice, if the government is unable to minimize the distance between the rich and the poor, if the government is unable to give you jobs, employment opportunities, education, sanitation, you have to promote, you have the right to promote disaffection towards this government. That is how you can bring in another government. That's how you can vote in favor of another government. So there should be no restriction. You can promote disaffection against the government established by law. So sedition is not a reasonable restriction under Article 19, Clause 2 of the Constitution. But what was not a restriction was made into a restriction by the Supreme Court. What was not part of the Constitution was entered through back door by the Supreme Court in Kedarnath Singh case. In Kedarnath Singh, the Supreme Court said sedition is constitutional. You can promote you have the power to say whatever you have to say, but do not incite people to violence. Don't incite people to violence, because if you incite people to violence, you have committed sedition. So although sedition was not a reasonable restriction on your freedom of speech and expression, but two things happened in Kedarnath Singh case. In Kedarnath Singh case, Supreme Court upheld the validity of section 124 capital A, saying yes, sedition is constitutional. But you cannot promote disaffection against the government established by law through violence. You cannot do that. So you cannot ask people to raise AK-47, to raise arms and ammunition, and let's overthrow the government established by law in Delhi, or let's overthrow the state government. That you cannot do. If you are doing this, you have committed sedition. That means in Kedarnath Singh case, one thing that Supreme Court said is sedition is a reasonable restriction on your freedom of speech and expression. But sedition in the sense, you can say whatever you have to say. You can promote disaffection against the government as well. But the only thing that you should not do not incite people to violence. Promote disaffection through writings, through articles, through whatever you have to say, but don't incite people to violence. If you incite people to violence, we will book you under sedition. Same thing happened in Balwant Singh case versus state of Punjab. When Indira Gandhi was assassinated, when there was a Khalistani movement going on in Punjab, where some members of the Punjabi Sikh community, they wanted a separate country for Sikhs. That country would be known as Khalistan. So then various slogans were raised. Raj Karega Khalsa, Khalistan Zindabad. And then these sloganers, those who were raising the slogans, they were arrested. They were arrested under sedition. Why? Because you are promoting disaffection against the government established by law. You are saying something which goes against which promotes disaffection against the government established by law. The Supreme Court said, no, this is not sedition. Because these are only slogans. Raj Karega Khalsa, Khalistan Zindabad, these are slogans. They're not inciting people to violence. So if by their slogans there is violence, then they will be booked for sedition. Otherwise, they will not be booked for sedition. In Shreya Singhal case 2015, the Supreme Court went a step further. Supreme Court said, say whatever you have to say, express whatever you have to express, advocate whatever you have to advocate, but do not incite people to violence. You can even advocate that this BJP government at the center should be thrown out of power. That this Congress government in Rajasthan should be thrown out of power. You can advocate even that. But not by calling people to raise arms and overthrow the government of India. You can say, overthrow this government of India through democratic means. Let's have elections, and these elections you should vote against the BJP, against the Congress. So you're calling for disaffection against the government, but through democratic means, through elections, through protests. But if you incite people to violence, it will be sedition and you will be booked and sentenced to 3 years in jail. That is Article 19(1)(a). Let's recap. Article 19(1)(a), simple terms means freedom of speech and expression. And this fundamental right is exclusively available to the citizens. But this freedom of speech and expression has been expanded to such a manner that those rights which originally were not part of the Constitution were given to us. For example, flying national flag is a symbol of expression. Right to silence is a fundamental right. Right to press is a fundamental right. Right to make an informed choice is a fundamental right. Right to ask questions. Right to information, specifically the voter's right to know the antecedents of a candidate. All these are fundamental rights under Article 19(1)(a). But this fundamental right is not absolute. It comes under reasonable restrictions. So your freedom of speech and expression can be restricted on 8 grounds. In the interest of sovereignty and integrity of India, public order, contempt of court, defamation, incitement to an offense, friendly relations with foreign countries, security of the state. On 8 grounds, there can be reasonable restrictions imposed on your freedom of speech and expression. For example, public order. Public order in the sense that you are in a theater and you are crying fire, 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 but then there is no fire. And when you said when you cried fire, 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 there was a stampede and hundreds of individuals lost their lives in the stampede. Now, if the police is arresting you, you cannot say, I have the freedom of speech and expression. I can say whatever I have to say. But whatever you said, it has to be reasonable as well. You said something which led to violation of public order, you will be prosecuted. But then there are others who say this ground public order is very vague and it affects creative personalities, particularly movies, films. How? Vishwarupam, a movie by Kamal Hassan, portrayed Muslims in a different picture. Muslims protested saying we cannot be terrorists. Vishwarupam was banned. Tamil Nadu government was asked, why do you ban Vishwarupam? Said, because this movie has raised some issue, this will violate public order. We cannot accept violation of public order. We have to ban this movie. Movie Padmavati was made by Sanjay Leela Bansali, in which it was shown maybe some kind of a relationship between Khilji and Padmavat. And ultimately, it was not acceptable to the Rajputs. It was not acceptable to some members in Rajasthan. Buses were burned, school buses were destroyed, riots took place. And it was argued that we should ban this book, we should ban this movie. And then Sanjay Leela Bansali was asked, can you change the name of this movie? He said, okay, I'll do that. If there are two options, either you have to ban this movie or I have to change this name. He changed the name of this movie Padmavati to Padmavat. By removing I, nobody would come to know that it speaks of the real Padmavat. Whether true, wrong, genuine, not genuine, we don't know. But it assumes, it gives us a sense that India is becoming from Hindustan to Banistan. You don't like a book, ban it. Salman Rushdie wrote a book, it was banned by Rajiv Gandhi. Movie Fana was made by Amir Khan, it was banned by Mr. Modi in Gujarat. So we are becoming intolerant when it comes to freedom of speech and expression. This is where Voltaire becomes important. Famous philosopher Voltaire said, I disagree with whatever you say, but I will defend till death your right to say it. So if you don't like a movie, don't watch it. If you don't like the Besharam Rang of Pathan, don't watch it. You can boycott it as well, but you can't stop others from watching this movie in the name of public order. The government should not ban these movies just because there will be violation of public order. Because then today, it amounts to censorship. Censorship in the sense, today a creative filmmaker is writing a beautiful story, but then he cannot make that movie. Why? Because he anticipates that people will start protesting against this movie. What is censorship? Stopping you from publishing something. That's censorship. So it is now a different form of censorship known as self-censorship. Censorship previously was when in the 1975 emergency was imposed in India. Whatever articles were to be published by the newspapers, first will go to the government. Government will see whether something anti-government is mentioned in these articles. If something anti-government is mentioned in these articles you cannot publish. Those which praise the government, these articles you can publish. That was what was called censorship. And once Indian Express had to release an editorial during emergency, this editorial was not allowed by the central government. It was blocked by the central government. What Indian Express did, it released that newspaper, but kept the editorial column blank to tell the public that there is something fishy here. We wanted to write something, but we are not allowed to write that. That is censorship. Now, this censorship has taken another form, self-censorship. I'm scared of writing a book. I'm scared of writing the script of a movie because I fear that tomorrow people will start protesting against this. So I stop that idea and I make another idea. I make a movie which will be lapped on by the audience. Nationalist movies I start to make. I don't make movies which are slightly different from the crowd. That is what we call self-censorship. And self-censorship is affecting the creative pursuits of the filmmakers and the personalities. Because movies, they have a short shelf life. If a movie does not do well on Friday, Saturday and Sunday, the first weekend, the movie is a flop. In most of the cases. In other cases, the word of the mouth plays an important role so that this movie, even if it struggles in the first weekend, but it gathers pace and momentum in the subsequent weeks because everybody starts talking about this movie. So if I'm the producer, I don't want any controversy. I don't want this movie to be blocked on a Friday because then my business would be affected. I have spent hundreds of crores on this movie and I will lose this entire money. So then what I do, I meet Raj Thackeray. Mr. Raj Thackeray, you first see my movie. See, there is no Pakistani actor here. There is no Pakistani singer here. Now, please, can you give us the permission to release this movie? Who is Raj Thackeray? He's nobody. He's not holding any position. But he's like the censor of India. I will decide which movie will get released in Mumbai. If there is a Pakistani actor, if there is a Pakistani singer, if it affects Marathi Manus, if it is anti this, anti that, we will not allow its release. Because then my men will throw stones at the cinema halls and we will block the release of this movie. They are threatening public order. And that is how they get away with these threats. That is why the government should rein in these forces, ensure enough protection to these filmmakers, in a sense, enough police protection so that nobody can disturb the screening of a movie. If you don't like my movie, write a critical review of my movie. Make a counter movie. Don't like my book, don't read it. But you cannot stop me from writing. You cannot stop me from expressing myself. That is how we can become a mature society. Sedition, which basically means promoting disaffection, not against the nation, but against the government established by law. This provision was used primarily to target the nationalist movement for freedom. After the commencement of the Constitution, sedition was not a reasonable restriction on your freedom of speech and expression. You can say whatever you have to say, even you can promote disaffection against the government. But then the sedition law was upheld in Kedarnath case, but Supreme Court said you can still promote disaffection without inciting people to violence. Mere slogans, no matter how irresponsible they are, such as Raj Karega Khalsa, Khalistan Zindabad, although these slogans are horrible, but then these slogans do not constitute sedition. Because unless and until you are inciting people to violence, it is not sedition. And in Shah Singhal case, Supreme Court said, say whatever you have to say, express whatever you have to express, advocate whatever you have to express. Advocate, but don't incite people to violence. That is Article 19(1)(a) of the Constitution. Any questions, let me know, then we will start with other rights. Incitement means provoking. I'm provoking you to commit violence. What type of punishment will be there if person commits sedition? 3 years in jail. Or fine as well, or both. Defamation type not getting. Defamation type in the sense, one is libel, the other is slander. If you are defaming me through your writing, when you have written something, that is what we call libel. If you have defamed me by giving a speech, oral speech, that is called slander. So sedition can be misused. It has been misused. It is being misused. And that is why now the case is before the court. What the Supreme Court has said, no further arrests under sedition, unless and until we decide whether it is okay to continue with sedition or not. So no arrests under sedition now. Okay. Now let's look at other fundamental rights under the Article 19, and we will discuss them briefly one by one because these are relevant for prelims mostly, not for mains. There is an element of mains as well, but that we will discuss. We have to spend more effort and time on 19(1)(a) because it is almost always in the news. Article 19(1)(b) talks about right of assembly. Right of assembly means right to hold protests, demonstrations, right to assemble at a public place. This is your fundamental right. But this is not an absolute fundamental right. Because on one hand, Constitution is giving you the right. On the other hand, the Constitution is imposing restrictions on your rights. If you have the right of assembly, that means as a group you can assemble somewhere. You cannot say, sir, tomorrow we will come to your house. We will assemble there. No, that's not your fundamental right. Right to assemble at a public place. Clear? and right to assemble at a public place without arms as well. You cannot say, sir, I have the right of assembly, which means I can assemble at a public place, but I can also assemble with AK-47 assault rifles, with Kalashnikovs, with other weapons. That is something that is not allowed. This meeting has to be unarmed. This meeting has to be peaceful. And this right of assembly can also be restricted in the interest of public order or in the interest of sovereignty and integrity of India. In a sense, you want to carry out a protest. But if you carry out this protest, there is an apprehension that slogans will be raised, buses will be burnt, stones will be pelted. This will violate public order. We will not give you the permission to hold this assembly. This is where Section 141, 144 is used. For example, you have to write the civil services examination. Once you write the civil services examination, outside of the examination hall, in majority of the cases, Section 144 is imposed. That means assembly of more than 4 people is banned. Which means if there are more than 4 people assembling outside this examination hall, it may lead to disturbance of public order. People may resort to cheating as well. That is why restriction is imposed on your right of assembly. Similarly, if you want to organize a rally, but you want to organize a rally calling that Tamil Nadu should come out of the Union of India. We are organizing a rally, we will assemble peacefully without arms. But what is our demand? Our demand is that we want to come out, we want to secede from the Union of India. That rally will not be allowed. Why? Because it goes against the sovereignty and integrity of India. So what is right of assembly? The fundamental right to the citizens of India that you can assemble peacefully, unarmed, at a public place. That's your fundamental right. But this fundamental right is not absolute. Reasonable restrictions can be imposed. In the interest of public order, reasonable restriction can be imposed. In the interest of the sovereignty or integrity of India, reasonable restriction can be imposed. For example, there were protests in Delhi after the enactment of the Citizenship Amendment Act, and these protests were held at Shaheen Bagh. When the protests were held at Shaheen Bagh, it was a peaceful protest. People were unarmed. People were not holding any arms. It was a peaceful protest. But then this protest at Shaheen Bagh, it blocked important roads. And by blocking important roads, it caused inconvenience to the public as well. When it caused inconvenience to the public, they approached the Supreme Court. Supreme Court was asked that please direct that this protest at Shaheen Bagh should be stopped, or a separate place should be given to these protesters where they can protest, so that they are not causing inconvenience to other members of the society. They are not violating public order as well. The court agreed, and court said the government should designate a special place for such protests. Right to protest is your fundamental right. Right to assemble peacefully at a public place is your fundamental right. So we cannot stop it if it is unarmed, if it is peaceful, if it is not against the sovereignty and integrity of India. If in this public assembly you are not giving hate speeches, if it's a peaceful protest, we will allow it. But if you are blocking a public place which is causing inconvenience to other sections of the society, what the government has to do, the government has to set up, demarcate a special place where people can protest without causing inconvenience to others. That is Article 19(1)(b), right of assembly. Is that clear? What is the new name of sedition? There is no new name of sedition. Sedition is sedition. Sedition was sedition. Okay. Second one, 191C, right to form union, association, or cooperative society. This term, cooperative society, was added by 97th Constitutional Amendment Act 2011-2012. So all the citizens of India, they have a fundamental right. What is the fundamental right? You can form a union, a students' union, an employees' union. You can form an association, a resident welfare association, shopkeepers welfare association, any association. Or you can form a cooperative society. What is a cooperative society? For example, Amul is a cooperative society. All the milk farmers of Anand district in Gujarat, what they have done, they have formed a cooperative society. Let's take the milk from all the dairy farmers and use it together. This milk can be used as milk to be supplied, paneer, curd, ghee, other dairy products, and whatever money we generate, whatever profit we generate, that will be equally distributed amongst the members of this cooperative society. That's a cooperative society. For example, a group of people coming together, cooperating, coming together, and they have a principal objective of, let's say, supplying milk to other members of the society, other regions of India, other states of India. That's a cooperative society. Amul is the shining example of cooperative society. That is your fundamental right. That means you have the fundamental right to form a union, to form an association. And in 2011, another fundamental right was given, that you have the fundamental right to form a cooperative society as well. But this fundamental right also is not absolute. And it should not be absolute. If I have the fundamental right to form another union, association, cooperative society, can I also create a terrorist association? I will create another Al-Qaeda. I will create another Ulfa. I will create another LTTE for that matter, a terrorist organization, and tell the Constitution of India, tell the Supreme Court of India, see, I have the fundamental right to form any union, association, cooperative society. We are a group of terrorists who are cooperating with each other to kill the people of India. That's our fundamental right. That is why even this fundamental right is not absolute. It can be restricted on the grounds of sovereignty and integrity of India, which means you cannot form a terrorist group which goes against the sovereignty and integrity of India. You want to disintegrate India by indulging in terrorism. That we will not allow. We will not allow you to form a society or an organization or an association which violates public order or which is against morality. For example, the group of people come together, we want to form an association, All India Association for Pornography. This is against morality of India. This we will not allow. Apart from that, if you want to create political unions, student unions, you want to form a political party, that's your fundamental right under Article 19(1)(c) of the Constitution. You can even set up a company. That is your fundamental right under Article 19(1)(c) of the Constitution. Then Article 1D and Article 19(1)(e), they're mostly similar. Similar in the sense, they both try to implement something. And what do they try to implement? One of the objectives of the Constitution mentioned in the preamble, and that is fraternity. What is fraternity? Article 19(1)(d). All the citizens of India, they have the fundamental right of movement. They can move freely throughout the territory of India. So Tamils can come to Karnataka, Kannadigas can go to Kerala, people of Odisha can go to Jharkhand, people from Jharkhand can go to Jammu and Kashmir, people from Assam can go to any other state. You have the right of movement. You have the fundamental right to freely travel, freely move throughout the territory of India. And when we freely allow people to move within the territory of India, we get in touch with each other. Northern India gets in touch with Southern India. Southern India gets in touch with the Western and Eastern India. What are we trying to achieve? A sense of common brotherhood amongst different sections of the society in India. So we are trying to implement fraternity. But even this fundamental right is not absolute. Reasonable restrictions can be imposed on your free movement. Reasonable restrictions in the interest of the general public and for the protection of the interests of any scheduled tribe. What is the interest of the general public? Simple. COVID-19 struck India. Now, all those who are COVID-19 positive, they are to be quarantined at home. Now, you can't break the quarantine and say, how dare you stop me? How dare you isolate me? Quarantine in my home. I have the fundamental right of movement. I can move freely without any disturbance. I can move freely throughout the territory of India. I want to go out of my home and I want to travel to Delhi. I said, please listen to me. You will spread this virus in Delhi as well. Stop, we will not allow you. Why? Because it is for the interest of the general public. Your freedom of movement can be restricted. Similarly, in the interest of scheduled tribes. Who are these tribes? We will discuss in great detail when we will look at the Schedule 5 and Schedule 6 of the Constitution. But very briefly here, tribes are basically known as aboriginals. These are the original inhabitants of this country. In a sense, it is argued, some people discredit this theory, some people accept this theory. But whether it is right or wrong, I don't know. I'm just telling you one information. And this information is known as the Aryan invasion theory. I don't know whether that is true or not. I don't know. Don't lynch me for that because it's very sensitive matter. According to some experts, Aryans came from outside, from Central Asia, for example. When they came from abroad, that means these are Aryans. These are not legitimate people of India. When they start coming from abroad, who were the people who were originally residing in India? These were the tribals. When Aryans came from abroad, these tribals, they were pushed towards the forests. And then they started remaining in these forests. And they maintained their individuality. They maintained their identity. They maintained their own culture. They maintained their own script, whatever it is. And they remained distinct from other sections of the society, from the people of the mainstream India. For example, the Jarawas of Andaman and Nicobar, the Sentinelese of various islands in India, they remain distinct from the other sections of the society. Now, the question before the policy makers, before the makers of the constitution was, how do we deal with these tribals? Should we allow non-tribals to move into these areas? Should we do that or should we not do that? Pandit Nehru had an advisor. His name was Verrier Alvin. Verrier Alvin and Pandit Nehru together, they decided that we should not interfere with the tribals. We should let them remain the way they are. If they want to maintain their distinctiveness, they should have the fundamental right to maintain their distinctiveness. And non-tribals, their movement to these tribal areas should be restricted so that we do not disturb these tribals. So if you want to go to Jarawa, you will not be allowed to. If you want to enter the Sentinelese Island, you will not be allowed to. Why? Because although that is part of the territory of India, but you have the right of movement as well. You can move freely throughout the territory of India. But in the interest of the scheduled tribes, your right of movement can be restricted. This right of movement has two dimensions. One is internal, the other is external. Internal in the sense, right of movement within the territory of India. So from north to south, from east to west, from center to east, you can move freely throughout the territory of India. That's the internal movement. External movement is right to travel abroad. And this right to travel abroad comes under Article 21 of the Constitution. So this movement has two dimensions, internal and external. Internal movement is covered under Article 19(1)(d) of the Constitution. But external movement, the right to travel abroad, comes under Article 21 of the Constitution. And I told you Article 19(1)(d) and E are mostly similar. Similar in the sense that they try to implement the fundamental right. They try to implement the objective of the Constitution, which is fraternity. And Article 19(1)(e) talks about right to residence. You have the right to reside and settle in any part of the territory of India. You're from Delhi, but you come to Karnataka, you have the fundamental right to reside and settle in Karnataka. Karnataka state cannot tell you, since you are from Delhi, we will not allow you to reside and settle in Karnataka. That cannot happen. Why? Because this is your fundamental right. You have the fundamental right to reside and settle anywhere within the territory of India. But even then, this fundamental right is not absolute. Absolute in the sense, in the interest of general public and for the protection of the interest of scheduled tribes, reasonable restriction can be imposed. In the interest of scheduled tribes, we know that to protect, to isolate the tribals from non-tribals, there is restriction in our movement to these tribal areas, and there is a restriction to our settling in these tribal areas as well. That is why when we said Citizenship Amendment Act will not apply to the tribal areas of Assam, Meghalaya, Mizoram and Tripura. Is that unconstitutional? No. Why? Because your right to settle, reside, if under CAA, migrants from Pakistan, Afghanistan, Bangladesh, belonging to Hindus, Christians, Buddhists, Jains, Sikhs and Parsis were given citizenship. Once they are citizens, that means Article 19 is a fundamental right for them? Yes. That means they have the right to reside and settle anywhere within the territory of India? Yes. Then how can we say that they will not be settled in the tribal areas of 6th schedule? Why? Because this right to reside is not an absolute fundamental right. In the interest of the scheduled tribes, your fundamental right to residence can be restricted. Similarly, in the interest of the general public, what is in the interest of the general public? For example, there is an individual. This individual is creating problems in our state. Repeatedly, he is creating problems. He is indulging in theft. He is indulging in dacoity. He is indulging in inciting people to violence. Every time we arrest him, he is convicted. When he goes back, he is again doing the same stuff. So he is somebody whom we call as habitual offender. He is habituated. It is his habit to offend. Clear? Now, what the courts can do? Courts can ask these habitual offenders to leave the state. Leave the state because you are a habitual offender. That means you cannot reside here. You can reside somewhere else for some years, then you can come back. But you cannot reside in this area for 2 years or 3 years. For example, the current BJP MLA who was previously with the Congress, previously he was an independent figure, a very charismatic figure, Hardik Patel in Gujarat. He started an agitation, Patidar agitation in Gujarat. He basically wanted reservation for the Patels. And he was giving a lot of speeches. He was violating lots of laws. He was violating public order as well. Repeatedly, he was inciting people to violence. So the court said you are a habitual offender. You leave Gujarat for some time. That means on your residence, there can be restrictions in the interest of the general public because you are violating the public order of the general public. For you, you cannot reside in Gujarat for some time. After that, you can come back, but for now, you have to leave Gujarat. That is what is called in Hindi, Tadi Par. You are expelled from Gujarat. In court, P. Arumugan versus State of Madras, the Supreme Court said restrictions of residence on those habitual offenders, they are reasonable restrictions on your right to residence. Clear? Rahul Gandhi sharing a picture of Adani and PM Modi in a peculiar way comes under sedition or not? Please explain, I am confused. Why is it sedition? Sedition is promoting disaffection against the government established by law, which means you should not incite people to violence. Through this picture, Rahul Gandhi is not inciting people to violence. When there is no violence, there is no sedition. Okay. 19(1)(f), right to property, was repealed by 44th Amendment 1978. And I told you we'll discuss that in DPSPs, why this fundamental right was removed. The last article under Article 19 is 19(1)(g), right of trade and occupation. You have a fundamental right. You want to become a doctor, that's your fundamental right. You want to become an engineer, that's your fundamental right. You want to become a businessman, that is your fundamental right. You can take up any trade, any occupation, any business. That is the fundamental right under Article 19(1)(g) of the Constitution. But even here, this fundamental right is not absolute. Absolute in the sense, number one, I have the fundamental right to take up any trade, occupation, profession. Clear? I've decided something. What have I decided? I want to sell drugs to people. Contraband, ganja, others, various other chemical drugs as well. That's my fundamental right. Police cannot arrest me. Why? Because I have the fundamental right to take up any trade, occupation, profession. And I've decided that my occupation is I want to sell drugs to the public. Who are you to stop me? I have the fundamental right. Today morning, polity sir said in the class, I have the fundamental right to take up any trade, any occupation, any profession. Either you are horrible or your teacher is horrible. This freedom is not uncontrolled. In the interest of the general public, restriction can be imposed on your choice of trade, occupation, and profession. So if you are saying that I have occupied now this trade, I want to sell drugs to the people, it is not in their interest. So we will stop you from selling drugs. That cannot be your trade. That cannot be your occupation. That cannot be your business. That's number one. Number two, assume for a while that you attended this class till now, suddenly you exited this class, and now you're very confident. You go to a hospital, for example, All India Institute of Medical Sciences. Make way for me. What? I am the doctor. Show me where is the operation theater. I want to perform a surgery. Sir, who are you? I'm a doctor. But how? I have the fundamental right to take up any trade occupation. So in the morning, I'm the doctor. Afternoon, I'll approach the Supreme Court. I'm the lawyer. I will take the case of A versus B. Said, who are you? I have the fundamental right to take up any trade occupation. So in the morning, I'm the doctor. In the afternoon, I'm the lawyer. Then in the evening, I'm the civil engineer. I will construct a bridge which will collapse tomorrow. And towards the night, I am a professor. I will also teach at the Anti-National University, JNU. You have the right to become a doctor, engineer, but for that, professional or technical qualification can be imposed. You have the right to become a doctor, but for that, fulfill MBBS as a criteria, minimum criteria. You can also become a lawyer, but for that, you need a law degree. You can also become an engineer, but for that, you need a civil engineering degree. That means, yes, you have the right to take up any trade, any occupation, any profession. But for different professions, different technical or professional qualifications can be imposed. Third restriction. State can carry on any trade or any business to the exclusion of private citizens, whether wholly or partially. What is a state? State under Article 12 of the Constitution. What the state can do? It can take up any trade and it can exclude citizens from that trade. For example, constructing or developing a nuclear weapon, dealing with atomic energy. Suddenly after this class, sir, make way for me. Why? Because I want to construct a nuclear weapon. I want to deal with atomic energy. Why? Because I can take up any trade, any occupation, any profession. No, there are some things which are meant for the state, some activities meant for the state. Atomic energy, making weapons, for example, nuclear weapons, for example, you can't take that as your trade because the state has kept all of it in itself, in its own hands. So the state can take up, can carry on any trade or business wherein it can exclude private citizens as well, whether completely or partially. For example, railways, private players can be either completely or partially excluded from this. That is Article 19(1)(g) of the Constitution, and that completes our discussion on Article 19. Any questions, let me know, then we will jump to Article 20. Ashok, what's your question? Sedition leads to violation of public order. Because what is sedition? According to Supreme Court's interpretation, if you incite people to violence, then that is sedition. And through incitement of an offense, when you incite people to violence, it violates public order as well. So the link is sedition leads to violation of public order. Morality restriction on the ground on the right to form union. You cannot form a union, let's say, of all those who want to, let's say, indulge in pornography. So All India Pornographers Association, that is something that you cannot create because by itself, this organization is obscene, immoral. So in the interest of morality, restrictions can be imposed on your right to form a union. So the judgment you told for Shreya Singhal case, Anubhav sir told that judgment for Kedarnath case 1962, which is correct. In Kedarnath case, the Supreme Court upheld the validity of sedition. And the Supreme Court said, don't incite people to violence. Apart from that, you can do anything. The same thing was reiterated by the Supreme Court in the Shreya Singhal case. And in Shreya Singhal case, for the first time, Supreme Court explained what do we mean by speech. Supreme Court said, say whatever you have to say, express whatever you have to express, advocate also whatever you have to advocate, even if you have to advocate change of the government, but don't incite people to violence. Sedition is a reasonable restriction on 19(1)(a). Is that right? No, it's not, because it's not mentioned in the 8 restrictions. Not phonograph, pornography. Movie Pathan had many obscene scenes. Can it come under Hicklin test? No. Don't watch that movie if you don't like it. Okay? What is obscene to you may be completely normal to me. That's where the court has to look at the contemporary standards of morality. Okay. Now let's look at Article 20 of the Constitution, and there we have to discuss 3 clauses. Article 20, Clause 1, 20, Clause 2, 20, Clause 3. You don't have to memorize clause by clause, just understand the concept. What is the concept? Article 20, Clause 1. What is Article 20, Clause 1? December 16, 2012. Something happened. A physiotherapy student, along with her friend, they were moving in a they went to watch a movie, then they boarded a bus, and then they were assaulted. 6 people assaulted them, and this lady, this physiotherapy student, she was gang raped in a moving bus, and then she was thrown out of the bus, and then she passed away. She was taken to a hospital, then she was sent to a Singapore hospital, and ultimately she passed away. Her name is what she is known as now, Nirbhaya, fearless. One of the individual who was responsible for this gang rape was a juvenile. Now, who is a juvenile? In the year 2012, the definition of juvenile was somebody who is less than the age of 18. And the law, according to 2012, said, if a juvenile has committed any crime, this juvenile cannot be tried like an adult. Adults will be tried in a different court. Juveniles will be tried in a different court. Adults will be sent to a different jail. Juveniles will be sent to a reform home. And the maximum punishment that can be given to a juvenile, regardless of the crime, maximum punishment that can be given is 3 years. That too not in a regular jail, but in a reform home. And after you have spent 3 years in a reform home, you will be set free. This is the law which was in place in 2012, when Nirbhaya was gang raped and one of the rapists was a juvenile. After that, there was a demand, there was a series of protests. Indian Penal Code was changed. Lots and lots of changes were made in the laws for the safety of the women after this horrific gang rape of Nirbhaya in 2012. And in 2015, laws related to juveniles were changed. Why? Because it was argued that this juvenile who was just few months short of 18, if you are old enough to rape, you are old enough to hang as well. So if you have the understanding of what rape is, you should be prosecuted for rape as well. And we have seen that there is a group in the age group of 16 to 18. There is increased incidents of crime committed by this group of juveniles, particularly in the group of 16 to 18 years. And they should be tried like adults. They should be tried in a regular court. They should be sent to a regular jail. They should be given life imprisonment as well. This was the demand. And when this demand was met, Juvenile Justice Law of 2015 was passed. According to this law, if a juvenile who is in the age group of 16 to 18 has committed a heinous crime. And what is a heinous crime? Any crime whose punishment is more than 7 years. Under Indian Penal Code, when we have the list of crimes, all those crimes for which the punishment is 7 years or more, minimum 7 years of punishment, that crime becomes a heinous crime. For example, rape, for example, murder, for example, terrorism, for example, dacoity. And if this juvenile in the age group of 16 to 18 has committed a heinous crime, he can be tried like an adult. He can be sentenced to life imprisonment as well. But death sentence will not be given because you are in the age group of 16 to 18, but you will be tried as an adult. Now, these individuals who were arrested in 2012, according to this 2012 case, when they were arrested, this juvenile, will he be prosecuted under the new law or under the old law? Let's assume for a while that this case is continuing in 2015 as well, 2016 as well. And when this case is continuing, the law has changed. When the law has changed, it says this person, this juvenile in the age group of 16 to 18 can be tried as an adult. Will this changed law apply to this juvenile? No. Why? No person shall be convicted of any offense except for the violation of the law in force at the time of the commencement of the act. What was the law which was in force when this crime was committed? The law said this juvenile can be sentenced to a maximum jail term of 3 years. And even if after this crime, the law has changed, you will still be booked under that law, not under the changed law. That is Article 20, Clause 1. And this Article 20, Clause 1 is similar to ex post facto or no ex post facto laws which we see in the American Constitution, in the US Constitution. What does that mean? Let's say, for example, I'm teaching you right now. Clear? Is this a crime to teach you? No. Am I doing anything illegal? No. Am I doing anything immoral? No. Now I'm teaching you. And I have my eyes on 2024. I want to contest Lok Sabha elections in 2024. This is just an example. I'm not a politician. I do not intend to join politics as well. Just to make it understand, just to make it clear to you, I want to contest 2024 elections. From which constituency? Varanasi constituency of Mr. Modi. And now it's 2023. I'm starting my campaigning in Varanasi. I'm meeting people. Suddenly, Mr. Modi gets the wind of this. He realizes that I'm in danger. This person may win the election. So what he does, he has the majority in the parliament. Parliament passes a law. Whoever is teaching polity at Byju's is a criminal. And this criminal cannot contest Lok Sabha elections. I said, okay, I will resign from Byju's. Said, no, not only this. This law, which is passed in, let's say, December 2023, will enter into force from January 2015. That means this law was passed in 2023, but we will give effect to this law from a previous date. We will say from January 2015. Whoever is teaching polity in Byju's is a criminal, cannot contest Lok Sabha election. Because I started teaching at Byju's in January 2015. Mr. Modi, you know this. This cannot happen. No ex post facto law. That means you cannot pass a criminal law and give it a retrospective effect. You cannot pass a criminal law today and say this law will enter into force from a previous date. Because if I was knowing that teaching polity in Byju's is a crime, I would not have joined Byju's. I would not have started teaching polity. You can't say that today it's not a crime, but 10 years later you say no, 10 years ago it was a crime. That means you are giving a retrospective effect to a criminal law. This cannot happen. This is banned in the US Constitution. This is banned in India as well. That means Article 21 is a limitation on legislature. What legislature you cannot do? You cannot pass a criminal law and give it a retrospective effect. But civil laws can be given retrospective effect. For example, there is a law related to taxation. It can be given retrospective effect. For example, a law is passed today, a tax is imposed today, but you can say this tax will remain in force from a previous date, from 2018, from 2017. But a criminal law cannot be given retrospective effect. That's the second meaning of Article 20, Clause 1. So what is Article 20, Clause 1? Basically two things. Number one, there is a limitation on the parliament. There is a limitation on the legislature. That dear legislature, whenever you are passing a criminal law, give it a prospective date. Say this law will enter into force now, or law will enter into force after a year, or law will enter into force after 2 years, or law will enter into force after 3 years. Don't say this criminal law will enter into force from a previous year, from a previous date, from 10 years ago. That is a limitation that you cannot do. But for a civil law, you can give a retrospective effect. Second implication of Article 20, Clause 1 is, I can be arrested, prosecuted only for an offense if it was an offense when I committed this. Later on, it cannot be an offense for me. In a sense, if, for example, this juvenile, when he committed rape, what was the law at that time? The law said you can be sentenced to 3 years in reform home. Even if this juvenile is arrested in 2023, for example, this juvenile, he was evading arrest, he had disappeared, and now in 2023, this juvenile is arrested. That means in 2023, which is the law? 2015 law. 2015 law says whoever is between 16 to 18, if you have committed a heinous crime, you will be tried like an adult, for which life imprisonment can be given to you. Now this juvenile who committed this crime in 2012 but is arrested in 2023, will he be prosecuted under the 2015 law, or will he be prosecuted under the law which was there in 2012? He will be prosecuted under the law which was in force when he committed this crime. And when did he commit this crime? In 2012. So he will still be sentenced to 3 years in jail, that too in a reform home. He will not be subjected to 2015 law. That is Article 20, Clause 1. Any questions? Sir, what is the current law for practice of untouchability? Current law is same: immediate arrest, automatic registration of FIR, no need for a preliminary inquiry, no need for permission by DSP or SP. This is the current status of untouchability law, known as the Atrocities Act. What is heinous crime exactly? Exactly, it is list of all those crimes under Indian Penal Code for which the minimum punishment is 7 years or more. That is a heinous crime. Okay. Now let's look at Article 20, Clause 2. Let's say, for example, I have committed murder. I have not committed murder. This is just an example. I have committed murder. I was arrested. The court said, yes, you are guilty. You are sentenced to 14 years in jail. Now I spent 14 years in jail. Now I'm checking my clock. 14 years are over. Tomorrow, day after, 14 years are now over. Now I'm stepping out of the jail. I'm seeing the open field for the first time. Wow, what a feeling to be free. Suddenly the police arrest me again. And the court has convicted me again. Court is saying another 14 years in jail. But sir, for what? For committing murder. What murder? I was in jail for 14 years. How? The same murder which you committed 14 years ago. But for that, I was already convicted and I've served my sentence. I stayed in jail for 14 years. This is cheating. This cannot happen. That is what we call no double jeopardy. No person shall be prosecuted and punished for the same offense more than once. But that doesn't mean this. What does it mean? If you understood it, only half of it, incorrectly, you would say, okay, I commit murder today, or let's say I commit theft today, which is an offense. I commit theft today, for which the court has sentenced me to a term of 3 years. I have remained in jail for 3 years. After that, I have the complete freedom to commit as many thefts as possible. Why? Because I was once convicted for this offense, which is theft. I cannot be convicted again for this offense, which is theft. That means now I can commit thefts after thefts. Nobody can stop me. Now, one act of theft is one offense. You commit theft again, that becomes second offense. For the same act, for example, previously you committed theft, you stole something from me. That is an offense for which you served 3 years in jail. If you steal something from me again, that becomes another offense for which you will be prosecuted again. Or if you steal something from another individual, that becomes another offense of theft for which you will be punished again. But for the same offense which you did, for example, in December 2022, for the same offense, you cannot be punished and prosecuted by the judiciary again. No person shall be prosecuted and punished for the same offense more than once. This is based on the maxim nemo debe bis vixari, which basically means a man shall not be brought into danger for one and the same offense more than once. And this is what is called as double jeopardy. No double jeopardy, no double punishment. This double jeopardy is a limitation for judiciary. Judiciary in the sense, under Article 20, Clause 1, we say this is a limitation on legislature. Legislature cannot enact a criminal law and give it a retrospective effect, give it shape, give it effect from a previous date. Similarly, 20 Clause 2 is binding on the judiciary. Judiciary cannot punish a person for the same offense more than once. That is not the power with the judiciary. That's a limitation on the judiciary. And that is what is known as Article 20, Clause 2. No person shall be prosecuted and punished for the same offense more than once. Any questions as of now? Okay. Now there can be a situation. For example, you are a government employee. For example, you are an IAS officer. And as an IAS officer, you have also committed a crime. For example, murder. Now for murder, you will be punished by the judiciary. You will be sentenced to 14 years in jail. And for the same murder, you will be dismissed by the government from the service. Is this not double jeopardy? Is this not punishment for the same offense more than once? That means as an IAS officer, you committed murder. Same murder, one murder. But for the same offense, the court is sending you to 14 years in jail. And for the same murder, your department is dismissing you from the service. Is it not double jeopardy? No, it's not. Why? Because double jeopardy is applicable on judiciary. It is imposed on judiciary. Judiciary cannot punish you for the same murder again. But basis that murder, if your parent department, if your organization is dismissing you from the service, that is constitutional. Why? Because you have violated their service rules. You have violated their rules of the law. They had clearly mentioned that you cannot do these things. If you do these things, you will be dismissed from the service. So for the same offense, you are being punished. But since judiciary is not punishing you twice, it is not violation of Article 20, Clause 2, because Article 20, Clause 2 is binding on the judiciary. No person shall be prosecuted and punished for the same offense more than once by the judiciary. But based on the crime which you have committed, if your organization is dismissing you from the service, that is not violation of Article 20, Clause 2, because your organization is not judiciary. That is Article 20, Clause 2. We will meet tomorrow, 6 o'clock in the morning. We'll discuss 20, Clause 3. And any doubt that you have regarding the Aftab Poonawala case will be resolved when we look at Article 20, Clause 3. And tomorrow is the most important lecture because tomorrow we'll start with Article 21, which is the most important fundamental right known as the right to life. So see you tomorrow, 6 o'clock in the morning, and let's have another fascinating discussion on Indian polity. Any questions as of now? Sir, please discuss Pirari Valan case, Rajiv Gandhi. That we will discuss in the office of governor, because that deals with the pardoning powers of the governor. We'll discuss there. Contempt of court, criminal contempt of court means if you are scandalizing the judiciary, judiciary has given an order. Let's say in EWS reservation, Supreme Court said EWS reservation is constitutional. If I tomorrow say, I use my freedom of speech and expression, and I say that these judges have given this verdict in favor of the government because they have met Mr. Modi, or Mr. Modi persuaded and pressurized them, or they have taken bribe, or they have indulged in corruption, I'm scandalizing the court. This is criminal contempt for which I will be punished. Do we need to learn the article by sequence? No need, just understand the concept. Let's meet tomorrow, 6 o'clock in the morning, and we'll discuss other provisions of the Constitution. See you tomorrow, 6 o'clock. And tomorrow, is it a Friday tomorrow? Yes, tomorrow we'll discuss previous year's question papers as well. Bye-bye. See you tomorrow. Stay safe. And please get in touch with subject matter experts if you have any doubts. See you tomorrow. Bye-bye.